Mr. Cochran.
First of all, thank you, Your Honor, for the recess. It was necessary for us to be able to talk and discuss this matter. We certainly appreciate the Court's indulgence in that regard. Your Honor, I stand before you today in a very, very serious, perhaps the most egregious, outrageous thing that's happened in this trial thus far. Excuse me, what's it? Yes, Your Honor. I was going to ask at the outset, this argument will be rather lengthy, and I would ask that Mr. Dietrich be excused for reasons that I think will become obvious during the course of the discussion, Your Honor.
I'm not going to excuse him at this point.
All right. Well, if the Court...
This is a discovery matter that has to do when things were done.
All right.
I don't think that has anything to do with his
If the
other
Court
testimony.
feels at some time appropriate, then I hope the Court will exercise that discretion.
All right.
The Court will recall that yesterday you recessed early because of what was a serious discovery violation in which the Court, in your own words, indicated that the arguments of the prosecutor were specious with regard to whether certain evidence was evidence or exhibits, and you indicated, quite frankly, they could do without that. And so after having done that in an effort to move this case along, and I think the Court is aware that certainly from our standpoint we've indicated we would like to get this case to the jury as soon as possible, we made an effort, or at least started to make an effort. Your Honor, it made it clear to all of us that Mr. Dietrich was to remain, we'd have access to look at the boards and to talk to Mr. Dietrich. The prosecutors didn't apparently understand that. You had to come back out and then ask them to leave. We were delayed by that. Finally, you asked them to leave, Sherry Lewis and Ms. Clark and the others, and they did finally leave. We then started to talk with Mr. Dietrich, Messrs. Blazer and Bailey. I had a brief encounter with him, and after a few questions from Mr. Blazer, this agent, this FBI agent, handed us a one-page report, which is supposedly a summary of what he had. He wrote this out and handed this to us. And this becomes really important because this was part of the disguise, part of the guile, if you will, of this agent in trying to throw us off. This was handed to me, actually. I then handed it to Blazer. And Blazer, however, being the lawyer that he is, continued to ask questions about reports that this man may have written and this booklet that he was carrying. I walked over at some point, and we talked about the booklet, and I then felt the need to call Your Honor out a second time, if you recall, because there was a question he wanted to talk with you, and I said, we don't do that in this court. You don't just talk to the judge. The judge talks to us. And I asked you to come out, and then you made an order, and as I said before, Ms. Clark concurred in that he turned that book over to us. And so now...
We summoned Ms. Clark at that point.
Yeah, we summoned Ms. Clark down, and then at some point when she sat and talked with him, Your Honor made the order, and I believe she did concur in that order. At that point. The book was then...
That was to make available to you the contents of the notebook that the agent had.
That's correct.
Right.
And we've been trying to get that, and we had to have your intercession. We then got the notebook, and at that point, it became clear exactly why he'd been so reluctant to provide that notebook to us. Now, you have now been provided a copy of this 5-page, single-space report entitled "The Search for the Source: Carpet Fibers Found on the Leather Glove and the Knit Hat in the O.J. Simpson Case." Now, Your Honor, yesterday you talked about sanctions and appropriate sanctions. And yesterday, my learned colleagues argued to you that preclusion of certain of the photographs was certainly appropriate, and I'll address that more as we talk about it. However, this more egregious discovery violation that's now surfaced, we think, requires even harsher sanctions. This prosecution's expert, FBI agent Dietrich, prepared a written report from this case. And this report basically summarizes his so-called rareness of the alleged beige fiber found in Bronco vehicles. And I'd like to quote from a wise judge on this very issue. Page 29, 129. Quote, "If it comes to pass that there are reports or that conclusions were reached and there was a deliberate manipulation of the process and an instruction to the witness not to prepare a report to avoid discovery, then those witnesses will not testify, and that is going to be the sanction." That was an order that I made early this year. Now, Your Honor, that might sound familiar, because those words came from Your Honor's mouth, from Your Honor's lips, and you said it on a number of occasions.
Standing right there.
Right, and you've said it more than once. And you said it in response to Mr. Rock Harmon's ranting about our supposed experts and whether they should be entitled to reports. You made it very, very clear that preclusion was the appropriate sanction that anyone should expect. Now, the prosecutors heard that, we heard it, in Sherry Lewis's latest brief, she quotes your remarks also. So, Your Honor, they knew what the rules were. It became very, very clear. And for Ms. Clark to stand here yesterday and to say to you, I didn't know, it must have been in my office some other place. Ms. Clark has not had a witness for 2 months, it seems, and she's had plenty of time. This is a fine lawyer who knows what she's doing. She's running this case. She's the leader. Make no mistake, the leader on their side. She knows what's going on. They're planning. They are ending this case with this evidence. And for them to come up with this, I think you can agree with this, is absolutely outrageous and totally egregious. And so I wanted to start off with letting Your Honor hear those words, which I think are very wise words and think they're very appropriate. And I think they probably lead us to the solution to this problem right off. So now, in this case, not only was a report prepared by this witness, and then he attempted to avoid disclosure, Your Honor, and to conceal its existence. We learned of the report only when you interceded, and we were allowed to photocopy the entire loose-leaf binder. And what does this new discovery consist of, Your Honor? And now you've had a chance to read it, so I won't bore you in detail. But it consists of a 5-page single-spaced report, which I've given you the title of. This report contains extensive figures about numbers. And you may say, well, Mr. Cochran, you could have done this, you could have gotten this, and we're not sleeping at the switch, Your Honor. We tried. Let me direct you to the bottom of page 2 of this report, to these words, the last paragraph. On January 31st, 1995, Julia Shaw, legal representative for DuPont, advised that all production information of type 1405 fiber is proprietary. And I can tell you further, and if you want to take testimony regarding this, we have an investigator who was given disinformation by the Maslin Company. Disinformation. They didn't give us the information, even though we tried to seek it just in a general sense. The FBI could get information we couldn't. They knew they had this. And I wouldn't be surprised if Maslin didn't go along with what the FBI had already told them to do, not to give us anything. So we couldn't have gotten it. So I want to make that clear right at the outset, Your Honor. So this report goes into a number of things, total number of cars, carpets, square yardage, and that sort of thing. And in addition, Your Honor, there are 50 additional pages of supporting documents on his research into this area. We have not given you, I don't think, a copy of the entire notebook, and perhaps we should do that before you are asked to rule on this matter. This includes information from many, many different sources. And just again, to briefly summarize the conversation that Diedrich had with Blazer, so you get an idea of the concealment and the guile that was involved here. Blazer first asked him where he'd obtained the information about the carpet. He mentioned Ford and Maslin. He asked him if he had any written information, and he said he did, although he did not go into detail. He asked him if we could have what he had obtained, and he said, possibly. A few minutes later, he gave us then the one-page report, which I'm going to ask to have marked as an exhibit and give you a copy of it, whatever our next exhibit is. This one-page handwritten outline providing the rough figures, etc. Blazer then asked him if this was all he had. He wouldn't answer the question directly, Your Honor. Kept saying this was the information. Blazer kept pressing him. He finally admitted there were source documents and that the one page he'd given me was not the source material. Blazer then asked him what he had. He reluctantly showed Blazer some letters that were in this binder. However, he never showed this report. He talked about it being his report or his research. Talked about starting this research last year, Your Honor, that it was completed several months ago. Clearly discoverable, Your Honor. We should have had this. And he goes on, and he did not turn this over, Your Honor, until you ordered him to do so. Preclusion, then, it seems to me, citing this learned judge, is the only reasonable remedy. Preclusion of the witness entirely, or preclusion of at least any testimony concerning commonness or rareness of the Bronco fiber. You talk about prejudice, Your Honor. Consider this. You saw the cross-examination of Bob Blazer. Thoughtful, to the point, concise. He asked questions at the end, Your Honor. The questions he asked dealt with, if you recall, the commonness or rarity of carpet fiber and whether or not police cars had been checked. If this report had been discovered, as it had been, he wouldn't have asked those kind of questions. We would have had this information. But that's the prejudice. Can't unring that bell. He asked those questions because they hid this from us. And when you talk about prejudice, you can't unring that bell if the court pleases. So we think that we've been severely prejudiced, and we meaning O.J. Simpson, who's here trying to get a fair trial, if they are then allowed to present testimony concerning this issue. We will not ask any questions on this topic during our part of the examination if and when this man testifies, if you don't preclude him totally. And we think they must also be precluded from doing the same. The elimination photographs, the elimination subject photographs, Your Honor, we're asking also they be precluded from using their exemplar hair boards and their 2 blue-black fiber boards. Prejudice, it is clear from the photos that the reference hairs of Mr. Simpson, that within their reference hairs, there's considerable variation, Your Honor, within each person. Hair comparisons are never done on the basis of photographs and never on the basis of a small portion of a single hair. Had we known that they had intended to do this, had they complied with Your Honor's rules, had they complied with the rules of the laws of the state of California, we would have handled this much differently. We would have had or made additional photographs, Your Honor, of the elimination subjects to show the great variation in hair and point out that some of the hairs of the so-called eliminated subjects, at least photographically, appear to be similar. Ray, the photographs of the blue-black fibers. Had we known the prosecution prepared photos, we would have compared them to the slides of the fibers to make sure that they were being presented in a way that was not misleading. Since Your Honor is aware that photographs can be manipulated easily to make things which are dissimilar appear similar. We would have done things far, far differently at a time when they have announced to the world that they have this wonderful, compelling case and they're about to rest. At the very end of their case, they do this, Your Honor. And so, we come back to the law, Your Honor. Ms. Clark said something very interesting, it seemed to me, in our little brief discussion of this motion. She said, well, it was just his report, as though that didn't make it discoverable. Well, let's look and see what the law says on that, Your Honor. 1054, and this Court's very aware of that, you've talked about it many, many times, deals with 1054.1, information to be disclosed by the prosecution. Let me skip down, because this Court knows this by rote, I'm sure, but let me just refresh everyone's recollection. 1054.1F. Relevant written or recorded statements of witnesses or reports of the statements of witnesses whom the prosecutor intends to call at the trial, including any reports or statements of experts made in conjunction with the case, including the results of physical or mental examinations, scientific tests, experiments, or comparisons which the prosecutor intends to offer in evidence at the trial. Now, Your Honor, all we've ever asked for during the course of this trial is a level playing field. We ask they be treated just like we've been treated. And I'm sure Your Honor will do that. But in addition to that, we now have additional information that we hope to have in court today, sent from back east, where this may not have been the first time that this particular agent has done this. We expect to have information by the end of the day that there was a case in Fairfax, Virginia in 1991, where this same surprise tactic was tried by this agent and the prosecution. And certainly what the information we have is one of the reasons that the testimony was precluded was because, again, of a discovery violation and the unfair attempt to do this to the defense. Now, we hope to have that today, along with still another case in Pennsylvania we expect to have today. Now, the court may ask, what about this whole thing with the FBI and the prosecution? Well, I need to point out to you only that Mr. Bodziak came in here and testified. An honorable witness who came in and said, I can say this and no more. He didn't become an advocate for the prosecution. He wasn't trying to hide things. In fact, in the course of the prosecution turning over all those documents, we asked the appropriate questions. That's what discovery is about. And in doing that, we were prepared to deal with that. There was no delay. They didn't hide anything back. And it pointed out, Your Honor, that Mr. Goldberg, I think, who had Mr. Bodziak, he understood what the obligation was. He works under Marcia Clark. So certainly she understood it. They complied with it with Bodziak and the FBI. Things went smoothly. There was no attempt to deceive. And we went right through it, Your Honor. So they can't come and claim they didn't understand what the deal was. But it's clear, Your Honor, that the reason we weren't given these photographs and things, because if we were given the photographs of the fibers, it would have piqued our interest. We would have asked questions about this question of the fibers and their supposed rareness or uncommonness. So this was calculated when they did this. And when the agent sat here in court yesterday and said those photographs and those boards were prepared some time ago, these reports were done in April or May, several months ago, that's no excuse for the prosecution, Your Honor. And I'm real sensitive about being the so-called head of a team where you take responsibility like a human being without gender. And so I remember in this very court, a time before I was even as lead counsel, we were held responsible for something we never even knew about or ever saw. The court said we knew or should have known was the test you gave us. And that test applies not only to the defense, it applies to the prosecution. And so in this instance, we also last night had occasion, Mr. Neufeld had occasion to speak with Mr. Schulberg. Mr. Schulberg indicated that, and they went through the photographs. Of the photographs the district attorney had indicated were turned over by Mr. Dietrich to Mr. Schulberg. And by the way, they worked together. Schulberg was apparently Dietrich's boss at some point. Mr. Schulberg never turned those over to us. He thought that those photographs were for him. We never got them. But we're not complaining about that because they were apparently given him. But he now says there, and I think Neufeld will correct me if I'm wrong, there were at least 13 photographs that he has never even seen. He never got. So a further violation. Is that right?
13 that are on the board.
13 that are on the boards that he never got. He never gave us any of them. But we won't complain about that. But there was a previous relation between this agent and Mr. Schulberg. And so he's prepared to so indicate that based upon the conversation last night. I've already indicated to the court that with regard to our investigation, this Maslin Corporation was not forthcoming. They did not give us information. In fact, it seems they gave us disinformation. Information that's proprietary generally, information the FBI would have that we could not get. And it's information, Your Honor, that's prejudicial to Mr. Simpson. And this is all, make no mistake about it, this is about Mr. Simpson. This is about whether Mr. Simpson can receive a fair trial. This is about a trial that started on September 26th, Your Honor, and you've gone out of your way to try to give us a fair trial. And to have this occur when we know we're coming to the end, when you have made it abundantly clear you don't want delays, that you want to move this on, when you warned all of us there'll be preclusion if we don't comply with the laws, and we have seen the sanctimonious, pious posturing by the prosecution so many times in this case, and now we find that the most egregious violation of all, calculated, comes forward on a day when our jury's sitting back there waiting, and you've told them this case is going to be over. And as the case whimpers to a conclusion, we've got to wait even now further. Because, Your Honor, we cannot just sit here and accept we haven't received certain photographs. We can't sit here and accept what's going on. This report we never got. What are we to do? We don't want to delay the proceedings. So what do you do to keep that from happening? In the spirit of what you're saying, you preclude these things. That's the only test. Even you said yesterday how tough it was as you sat there trying to think about how do I deal with this? And you oftentimes say we never make it easy on you. Well, this time it's not us. It's them have made it easy on you. And you know what, Judge? You never asked for a rose garden when you took this job. This is a tough job, and you're equal to the task. And you want to be equal in the way you've dealt with it. We felt the sting of your sanctions. We dealt with them like human beings, like we should. The prosecution has to do the same. They can't stand up here and give you a lot of mealy-mouthed explanations about yesterday's explaination. Well, it's an exhibit I'm not going to use. I don't know what this is. That doesn't fly. You've got to stand up ultimately. And I call upon them now to stand up and say that they are wrong. They made a mistake. They're caught. And under what you've told us, preclusion is the only appropriate remedy. Otherwise, Your Honor, how are we going to recover? How are we going to deal with this if you don't do that? Continuance isn't going to help. We don't want a continuance. Well, how long will it take us to get stuff and to get up to speed on things we should have had 3 months ago? It's totally, totally unfair. And
Mr. Cochran, which of these 13 photographs were not received by the prosecutor?
I know we have a one
defense,
lawyer
excuse me.
speaking rule, but I would ask to defer. I'm not concluded. I'm not finished yet. Can Mr. Neufeld answer that?
When you're
Thank you.
concluded, yes,
Some water, Your Honor.
certainly.
And when I've concluded, Your Honor, then Mr. Neufeld will stand before you and tell you that the photographs we've never seen or that Mr. Schulberg never got, and none of those reports we've seen anyway. With regard to the so-called elimination photographs, Your Honor, and just looking at those photographs, it's become clear to us. We ask Your Honor to look at one of these photographs. This. With regard, as I said, the elimination photographs, I've indicated to you already that there are great variations between a single individual and a single individual's hair strand. And so we need additional time to look at that, to prepare for cross-examination. But if the court precludes that, that doesn't become a real problem for us. But further, Your Honor, and I want to show this to Your Honor, and I'll show it to counsel first, in getting copies of these photographs of alleged hair strands, this agent or someone has taken what was K, a known hair, and made it a Q. So you see Q7, which I think was O.J. Simpson, and he's made it Q8A. So that K7, I'm sorry, K7, and made it Q8A, looking at the photograph. And I'll pass this up so Your Honor can see this. And I think, Your Honor, that again, this points out the kind of things that they're seeking to do. It occurs to me that, as I said before, the prosecution understands their duty. I was reminded by one of my colleagues that when I said they made a mistake, this is more than a mistake. This was calculated. This was intentional. This was a tactical decision to try to gain an advantage at the very end. This is because their case was going poorly. This is because they thought they were losing. They had to string or try to pull something. But it just won't work because there's something about truth, something about honesty that will be revealed. And that's exactly what happened in this particular case when you came out and ordered that report and allowed us to see this. So I'm going to ask you to look at those photographs. I'm going to ask you to look at the one-page report we're given, and it's just part of the deception that we were given. And finally, Your Honor, all I'm going to ask you to do, because Mr. Simpson can't address you on this issue, I'm going to ask you to do what is right and what is fair in these circumstances. We want to go ahead with this case and finish this case. This jury deserves nothing less. It's not their problem. It's the prosecution's problem when they intentionally do this, Your Honor, and they have to be held accountable. And the way you hold them accountable is to preclude this witness, or at minimum, preclude those things where they violated the discovery laws of the state of California. And there's no other remedy otherwise. Nothing else helps us, because you don't want to wait 2 or 3 months for us to get up to speed where we would have been, do you? And would you now please hear from Mr. Neufeld, Your Honor?
Mr. Neufeld, what I'm specifically interested in which of these 13 photographs were not received.
Yes. Just so I can explain to you the source of the information. I spoke to Mr. Schulberg last night, and he did say that he had received some photographs from Mr. Dietrich, and I asked him to give...
Where is Mr. Schulberg located?
He was in Virginia. He had been the head of the Hair and Trace Unit at the Federal Bureau of Investigation up until the late 80s when he retired. And I asked him to please read off the Q's and K's on every photograph that he had. He did that. I then gave the list to Chuck Morton this morning and asked him to compare that list to all the Q's and K's on the evidence boards that have been brought into court, and to give me a list of all items that appear on the boards that weren't on the list from Myron Schulberg, and they are as follows. K53.
Which board are we talking about?
I don't have it by board. Mr. Morton simply wrote out the list of K's and Q's. During a recess, I can actually do that, Your Honor, but I'm just going to give you the actual photograph identifications.
All right, K53.
K54, Q7A, Q3, Q1, Q3B, Q27, K19, Q7C, Q8B2, K18, K47, and K17. Your Honor, the only other just fact that I want to present to the court, which for clarification, the problem with these photographs that we received last night is that because someone changed the description, what once was thought to be a standard hair, reference hair from Mr. Simpson, has now become allegedly the photograph of some evidence of an unknown hair in this case. We would have to go back, number one, to check whether or not on the negatives or the contact strips of these photographs to know if in fact it is a K or it is a Q. Obviously, the person who made this description on these photographs wasn't sure and changed his mind. Also, we don't know whether or not these photographs on the board have had their descriptions changed as well, or whether other photographs on the board have had their identifications changed as well because they're glued to the board. We would need to see the backs of those photographs to see on how many other occasions The prosecution did that with these photographs. And then we would have to go back and look at the negatives to see, as well as any contemporaneous notes that Mr. Diedrich made when these photographs were taken, to confirm that it is a Q as opposed to a K or K as opposed to a Q. Because, as the court can readily see, unless you have some kind of note-taking, it's easy to confuse them. There's nothing so unusual about a photograph like this that one will readily know, oh, it's a K as opposed to a Q. So these photographs simply illustrate that problem to the court.
All right, for the record, you want to identify the markings on those photographs?
Yes, Your Honor. First is a photograph with a number on the back which says 17170 to 17179. It says on the back 408-08026. Originally it said K7. The K7 is crossed out, and written above it is Q8A. The second photograph, the numbering is 17, and there's a cross out on the number, Your Honor, but it looks like 17240 to 17249, but those numbers themselves have been crossed out and written over. And it then says 408-08026. Once again, there was a K7 which has been crossed out, and written over the K7 is Q8A, as in Albert.
Thank you.
Thank you.
Ms. Clark. I'm concerned about two things. The rareness report, and I'm concerned about the 13 photographs.
I only counted 11, Your Honor, but
I counted
be that
13.
with respect to, let me first start out with the report then. First of all, you know, Mr. Cochran has argued to this court in bad faith. He's very well aware of the fact that the prosecution did not know about this report until it came to the attention at the same time that it did for the defense, at which point I readily agreed it should be turned over. I had never seen it. I did not direct that it be prepared. I did not know the research was going on. I found out about the report last night and immediately turned it over. That's a far cry from the egregious and willful violations perpetrated on us by the defense throughout this case. Hiding witnesses, hiding reports. And what's very important to point out, Mr. Cochran read your words, but he obviously did not understand them. The words that he read stated that conclusions that are reached by expert witnesses must be turned over. Conclusions of this witness were indeed turned over. And this court also stated that if instructions were given not to prepare reports, preclusion would be the remedy. At no time has anyone on my team ever instructed a witness not to prepare a report, ever. Quite the contrary. Every witness, if we knew about anything ongoing, was instructed to prepare a report for immediate production. This research that was conducted by Agent Diedrich was done for his own purposes. Yes, tangentially, yes, this case triggered that. But this is something that is ongoing by all of the agents at the FBI. They don't just sit behind a microscope. When they see a fiber, they investigate the background. Now, what is important here is that obviously the reports turned over to counsel indicated very clearly what his conclusions were, that he identified the Bronco carpet fibers as being the source of the fibers found on the Rockingham glove and on the knit cap, and he gave enough information for them to go forward and contact Maslin. Obviously, then, the conclusions and opinions of the witness were turned over in an adequate form to allow the defense to do further inquiry. That is the point of discovery, so that they are informed, so that they can do their own investigation. Now, Mr. Cochran complains only today of the fact that months ago his research went nowhere, that Maslin was stonewalling, that they weren't being helpful. On previous occasions, when they have had trouble with a witness or with some agency getting information from them, they have not been shy about asking for our assistance, for the court's assistance. And where is the subpoena that they could have issued on Maslin for this information? Where is the request to the court for assistance to gain some help in getting the information from Maslin? They obviously knew where to go to get it. They obviously made these phone calls. They got some information from them. Why was no one told that they were having difficulty? They could have even done it ex parte with the court and never chose to do so. And now they're complaining that their own failure has caught them off guard. They had the information to go forward and do the research. They did a limited amount, stopped and decided it wasn't worth it and it wasn't important to them. Agent Diedrich did. He made the phone calls. Now, the problem with their position is that it's specious. They have the conclusions, they have his opinions. That's what the court properly indicated we had to turn over. Now, the cases that counsel is relying on indicate that we are required to turn over the reports of witnesses, their opinions, and their conclusions. And that is what we did. And that's what Agent Diedrich included in his reports. The report that is in front of this court now indicates only the information obtained from Maslin, pursuant to routine telephone inquiry that is conducted by the FBI whenever they find question fibers of an unknown source. And that's what he did. So what that is inquiry that supported the ultimate conclusion and opinion that the defense has had for months. We didn't delay in turning over Agent Diedrich's reports and notes, all of them. They've had them. Moreover, the complaint and the hue and cry over these photographs is ludicrous. They've had this evidence not once, not twice, but 3, and I think possibly 4 times in their custody, with multiple experts examining all of the evidence. Could they have taken photographs? Absolutely. On any of those occasions they could have. And what precludes them from doing so now? Nothing. Nothing. They're saying that they're very concerned about the photographs being representative. Fine. You know, you've taken the evidence 4 other times. You know, they didn't know what to do with it then. They didn't know how to take photographs. Now that they have an idea of how to do it from Agent Diedrich, maybe they can tell their experts to do it. Certainly the court will not hesitate to let them have the evidence again. But it's not a question of them not knowing what is here, not knowing what the conclusions were, not having an opportunity to have every expert they can get their hands on examine this stuff and come to his own conclusion. They've been denied nothing. There has never been a defendant in the history of this state, I warrant, that has had everybody bend over backwards for him the way this one has. We have shut down laboratories. We have sent evidence all over the country multiple times. We have allowed defense experts into our laboratories multiple times. We have dug up records going back God knows how long from other cases for this defendant on multiple occasions, reams and reams and reams of discovery. And they don't get some photographs of evidence that they've had in their control and possession on 4 separate occasions, and they're complaining. Go take photographs. Fine. This is nothing but a graphic depiction of what was seen under the microscope by our expert and by their multiple experts. They want to take pictures of their own. They're entitled to do so. Do I regret that the photographs they complain of were not turned over? Yes. We have nothing to hide. There is no reason for them not to have seen them, other than that it was an oversight. And although Mr. Cochran waxes eloquent about how I should be taking responsibility for the failure to turn these over, and I do, I've never heard Mr. Cochran do so for the defense. Never, not once. It's everybody else's fault, and we didn't know, and all that. I'm telling the court I take responsibility. I do. I do. I wish it had been turned over. Is it all this egregious? No, it's not. No, it's not. They have had the conclusions, they've had the opinions, they've had all the reports that are pertinent, that are discoverable under the statute. They wanted the underlying research done by Mr. Diedrich. Fine, now they have it. Had I known of it earlier, they would have had it earlier. They got it as soon as I knew about it. And the court knows that's what happened. The court was here yesterday when I was called down and shown for the first time the book prepared by Agent Diedrich that contains that report. I read the report myself last night for the first time. What the defense thinks they're going to do with the fact that an inquiry by telephone gave certain die information, formulations, and calculations, I have no idea. But they're entitled to do it.
Doesn't this report really speak to the rareness, the relative rareness of this particular fiber? And doesn't it eliminate, say for example, one of the things that piqued my interest yesterday, and I asked Mrs. Robertson to pull up the crime scene photos to see how many Ford automobiles were driven by the police officers to the crime scene. Mm-hmm. And I was sitting here looking to see how many Ford Tauruses there were at the crime scene. But now I know that Ford Taurus automobiles are eliminated from as a source of carpet,
Right.
which I found interesting.
Right. Right.
But the thing is, this report tells me how relatively few Ford Bronco automobiles there could possibly be that would, registered in the county of Los Angeles, that would have this carpet fiber, this particular formula and this particular color. And that's very compelling circumstantial evidence. I mean, it really narrows it down to where this carpet fiber came from, don't you think?
And I agree with you, Your Honor, but this is not, the problem I have with this is that this is information that is reposed in a third party. This is not information that is retained by the FBI.
Let me ask you one other question. When was this report completed by Mr. Diedrich?
I have no idea.
I don't consider it a report. I just consider it a narration of my investigation. Of my
When was it
inquiries.
completed?
I'm sorry?
When was it completed?
Sometime this year, I don't recall.
A month ago? 2 months ago?
A couple months ago, probably.
Okay. All right, Ms. Clark, any other comment?
Yes, Your Honor. The problem that I have with the defense argument is that obviously, they're arguing out of both sides of their mouth. They say, we don't have enough information, it wasn't fair that we didn't get this. Obviously, they did get enough information. They went to the source. They asked the questions. Their failure to follow up on the refusal of the company by requesting the assistance of the court or the prosecution is up to them. They chose to drop the ball at that point. That's their choice. But to now turn to us and say, it's our fault that they didn't follow up on that line of inquiry, we are required to give them the information necessary to challenge the evidence, and we did. And they began to do so and then dropped the ball. Now, had they gone to the court, requested assistance, and then not been able to get the information, I can understand that. But they dropped it. They went to Maslin, they didn't get the answer, or they did get an answer. I don't know what exactly occurred, but obviously they had enough information to follow through, and that's really the bottom line. That's what discovery is about. Now, I'm not saying I don't wish that we had turned this report over earlier. I do, because we don't need to be having all these delays right now. Is it compelling in the sense that this is an egregious violation? Again, I can only tell the court the defense was given information that they could have gone and followed through on. They did begin to, so obviously they had enough. And now that they do know, they can give it to their experts, and they can have their experts examine the reports, examine the underlying information, talk to anyone from Maslin that might help them, speak further to Agent Diedrich if that will help them. They're not precluded. They have a defense case to put on. But to preclude the people from putting on important evidence like this, in light of the fact that they have the report that contains the opinion and the conclusion of the expert with sufficient information furnished to the defense to follow up on that and see what they could find out. I mean, they have everything that they are entitled to under the law. What they're complaining is that something else was prepared that they did not see, that simply documents Mr. Diedrich's further investigation through phone calls to Maslin. This is a third party.
Does the report turned over by Mr. Diedrich previously contain this information?
The report turned over to the defense?
Yes.
You mean the one yesterday or earlier?
No, previously. His previous
No, it doesn't
reports.
contain the detailed information. It says it contains the opinion and conclusions about the match and about what fibers matched. It also contained information, I think, about the type of carpet fiber that it was, manufactured by Maslin.
Any indicia of its rarity? Number of vehicles produced that have
no.
this carpet,
I
this
don't
particular
believe
color?
so. I don't believe so because I didn't know that till last night. So if I didn't know, let me indicate what the photographs are that the defense is.
I was just about to ask that.
I thought so. Okay. The K53 and K54 are the exemplars of Cato and Chachi, the dogs. K47 is exemplar from Colin Yamauchi.
K7A, excuse me, Q7A,
No, I'm sorry, that's K47.
K47.
Now that's pretty interesting. If those are the photographs that the defense claims that they don't have, then they must have photographs of the other police officer exemplars that we took and lab personnel. If that's the only one. Because that's one of that series of the police officer and lab personnel elimination standards, Your Honor, that we have on the board. K47 is one of those.
All right. Go ahead.
So K17 is the exemplar from Nicole's dress. K18 is the exemplar from Ron Goldman's shirt.
K18?
18, yes. K19 is the exemplar from Ron Goldman's jeans. Q27 is fibers from the defendant's socks. Q8B2, fibers from the blue knit cap. Q7A, fibers from hair and fiber. I'm not sure if these are hair or fiber, Your Honor. Q7A from the Bundy glove. Q7C from the Bundy glove. And then Q1, Q3, and Q3B are from the Rockingham glove. I should indicate also that Tony Longhetti took 65 photographs to Mr. Schulberg along with the evidence. There were 30 additional photographs that were left with him because they were extras. And Mr. Neufeld asked him to give the photographs to him. He said he would. However, he's since checked the evidence log and seen that Tony Longhetti took all the evidence photographs back, and he therefore is probably not going to return the photographs to Mr. Neufeld. And Mr. Schulberg should talk to Mr. Neufeld about this. In any case, 65 photographs were given to Mr. Schulberg back in September of '94.
But did they include these?
Well, I'm taking Mr. Neufeld's word for it that they didn't. That's what he says. I don't know.
All right, the Cato and Chachi exemplars I'm not particularly excited about. I don't think either side really cares about the dog fibers. But the Bundy glove, Ronald Goldman, I mean, these are critical fibers.
These are just photographs, Your Honor. I know the court, I'm not going to say it again. I just think that we probably see the issue differently, but the defense has now had all of yesterday, last night, and this morning to look at all of these photographs. They've taken photographs of the boards themselves. How much more would they have done had they had these photographs earlier? If the defense is complaining that they want the opportunity to take photographs too, nothing prevents them from doing that. The evidence is readily available. It hasn't gone anywhere. It's in the same condition it always was. Nothing has been denied them. They are not precluded from it. And now they have examined all of the evidence. You know, by way of example, counsel points out that Bob Blazier asked a series of questions that would not have been asked. Well, certainly they would have. They were pointing out the fact that LAPD didn't do the research when they know that the FBI did. So, you know. So I don't think that it would have changed that cross-examination any. But the defense has now seen all of the photographs they're telling the court now that they did not have, they have seen. They have taken pictures of. How long do they need to look at a photograph to be ready for cross-examination? I mean, isn't that the bottom line here, Your Honor? We have an exhibit they saw the day before. We intend to introduce it. They've had now additional time to examine it. And how much more would they have done if they'd have the photograph a month ago?
All right, any other comment, Ms. Clark? Certainly. No, I don't. She's entitled to hear what it is you're saying.
Cite to the court a couple of cases on the discovery issue. Hines versus Superior Court, 20 Cal at 4th, 1818. Page 1822 and 1823. And Sandifer, Woods versus Superior Court, 25 Cal at 4th, 178, at page 182. both of which stand for the proposition that the underlying data on which an expert relies is not the subject of a discovery statute that is compelled to be turned over. We did not intend to offer the information given to Mr. Diedrich from Maslin Industries, simply that it was his opinion that the fibers matched, and show the fact that Bronco fibers did change over the years through the photographs, which pins it down to a 94 Bronco or late 93, I think we said. And that's it. We were not going to offer the information that Mr. Diedrich obtained from Maslin Industries, although there would arguably be some basis to do so because an expert can testify to some of the hearsay he relies on. That was never the intent. It wasn't the intent because I didn't know about it, but I could certainly understand the court precluding him from referring to that at all in light of the discovery issue. But at least according to the case law, the kind of information we're talking about with respect to the research done with Maslin is not discoverable in any event. His conclusion is, and it was turned over. With respect to the rarity,
Was the fact that it's consistent with the carpet in a late 93, early 94 Bronco, was that in Mr. Diedrich's original report?
I don't know. No. No, it was not. I can only come back to the fact that this was information that was readily discoverable by the defense as well, though. You know, it's not as though this was something that was reposed in the FBI. This is a third party that the defense had access to, gained access to, and could have sought further assistance from the court to gain further access to. I don't understand why subpoenas weren't issued for it, but they didn't.
All right, Ms. Clark? Anything else?
No, that's it, Your Honor. I just, they've seen all the photographs now. They've had overnight to look at them. They've had all day to look at them yesterday as well. If they want more time to look at them, I don't see what, the problem is this, Your Honor. Defense complains that they need 2 to 3 months to prepare for this, which is ridiculous. They've had 6 months. This case has been, they've had the reports concerning Mr. Diedrich's conclusion about the fact that the Bronco carpet fiber from O.J. Simpson's car matches those fibers on the Rockingham glove and the knit cap for at least 6 months, if not more. They've known where to find the information concerning the production of that carpet type for at least 6 months, if not more, by their own admission. And now they're complaining that they didn't do further or better research, and that's not our fault, and it's not our obligation. And if they're having trouble getting that information, it's up to them to let us know. We can't go knocking on their door and say, "Excuse me, have you had any trouble getting information lately?" That's something that they have to tell us. And with respect to the photographs, what benefit would they have had to see the photographs even if they existed 6 months ago? They look at the photographs. They want to take their own. They can take their own. They can still do that. And that's the bottom line, is there is no prejudice and there is no harm other than their own failure to follow up on their own lead.
All right. Counsel, let me just make a comment. I don't find the Hines case to be appropriately cited in this situation. The Hines case at 1823 states as follows: the report of a non-testifying expert, which is in some way utilized by a testifying expert, is not a document, at least in ordinary circumstances, which the defendant will intend to offer in evidence. It is not, therefore, literally embraced within the description of the statute. That such subsidiary report may be discoverable as an aspect of cross-examination of a testifying expert does not undermine this conclusion. This is a report by a testifying expert, not a non-testifying expert. So the Hines case has no application whatsoever to this situation.
Well, we're talking about the information obtained from a non-testifying party, which is Maslin.
I don't care what you call this. This is a report.
Thank you very kindly, Your Honor. I'm not going to stand here very long, Your Honor, because you've heard all this and the issues are clear. Certain things I just feel compelled to say, and then I'll sit down. Mr. Neufeld wants to make a clarification regarding the photographic exhibits, and I'll ask you to hear that also. Just briefly, Your Honor, we've heard a lot of legal mumbo-jumbo with regard to whether this is a report, and you just said it best. This report, Your Honor, is entitled The Search for the Source, Carpet Fibers, etc., the O.J. Simpson case. And if you look at this report, Your Honor, on every page, they're talking about O.J. Simpson throughout this report. That's folly for her to stand and say that. You saw the report, the booklet this FBI agent had O.J. Simpson on the outside. And so when she talks about Mr. Simpson getting special favors, never before has there been a defendant who's been subjected to every law enforcement helping in the case ever in the history of the state. We have to ask for things because we're fighting the power of the government and a man who's innocent. And that's what we're trying to do here. So let's make that clear. But I'm not, you've heard all that. And they can cite you cases as they oftentimes do that are never on point. But I'm going to cite you Ito on the law. Ito on the law in this case. And it says, if it comes to pass that there are reports or conclusions which were reached and there was a deliberate manipulation of the process, there'll be preclusion. You said that. That's the relevant law in this courtroom. We all abide by that. We've lived with that, and we do accept responsibility, contrary to what she said. She tried to accept it, then she tried to weasel out of it. And you have to accept it or not accept it. And there, it's very hard for Ms. Clark to say that she was wrong or this was intentional, and then she says, well, they saw the photographs overnight. Your Honor, I remember one time there was a situation where you gave them, like, as long as they wanted. They asked one time for a month over some little tiny thing if they wanted. And we were aghast. They wanted a month. It was early on in the trial. I don't think it ended up being a month. But now she says to us, we saw the photographs overnight. When we finished seeing those photographs last night, Your Honor, everything back east was already closed. And the last thing I wanted to bring to your attention is this whole thing about Maslin. And it's very interesting for the prosecution to make these kind of thoughts, these largesse thoughts. I used to be a prosecutor, so I can understand it. When the FBI calls Maslin, it's far different than a defense investigator calling Maslin. And Maslin gave us disinformation, saying this carpet was common, is what happened. Was common, not rare. And that's the whole thing. Every time you ask a question about that report we were given, which throws us off, they have to then somebody can say, well, this rareness and commonness thing, well, that's something I wasn't going to use. Well, as to whether or not Ms. Clark knew about this or not, she should have known. And that's the test you applied to us, Your Honor. She should have known. She's the leader of that team, and she's a very thorough lawyer who hasn't had a witness in a long time, was building to this point. So it seems to me, if Mr. Diedrich kept this from her, then she should take it up with him. But I would suggest that he knew it was there, and even now, Your Honor, he sits over there trying to tell you this isn't a report. This is not a report. I don't know what you'd call it. And I think that's the essence of it. So you've listened to us. Now it's time for action. You've heard us. It's up to you. We just want a level playing field. We want fairness here. And fairness, Your Honor, is preclusion. We don't want a continuance. We want to hold them to the same standard you have everybody else. And then all I have to do is cite Ito on law. I don't have to miscite any cases. I can cite, Your Honor. That's all I ask you to do. And would you listen to Mr. Neufeld now, briefly?
Just to clarify which photographs we're talking about?
That's all. Your Honor, there was a mention by Prosecutor Clark about K47. Mr. Morton says that that's actually it's a standard reference fiber from Q47, which is the knit hat. Apparently we can check it out. I mean, it's not a big deal. There may be just a misunderstanding here. That may be one of the standard blue-black fibers from the knit cap. So that's why it was a Q, it's not a K. We didn't include in this list any of the photographs from the elimination board. We never received any of them, period. So that's not on this list. None of those photographs were ever turned over.
All right, let me see K53 and K54. Mr. Escobar. All right, thank you. All right, may I see, I want you to just put the next board up, Mr. Escobar, and let's see what's there. All right, this is the known head hairs from Nicole Brown Simpson compared with some of the Q series. All right, on this particular board, Mr. Neufeld, are any of these photographs, any of those that were not turned over to Mr. Schulberg?
May they get closer together?
Sure. Sure.
May you go to the well, Your Honor?
Yes, he may. Any of these on my list?
Q1 is on your list, Your Honor. We didn't get Q1.
They had Q7B and Q23.
We got Q7B, and we did get Q23, but we did not get the Q1s. We didn't have that on the list?
No, I just found it. All right, thank you, Mr. Escobar. All right, this is known head hairs from Ronald Goldman, head hair from Ronald Goldman's shirt, compared with Q3C and Q3C. And Q23. I think you have all of those.
Yes.
All right.
Schulberg has all of them.
All right, the elimination board. All right, thank you.
Q8C. It wasn't on your list, but you have to understand, Mr. Morton looked at it very quickly this morning. But it's not on Mr. Schulberg's list. So I have Mr. Schulberg's list here also.
Well, I have 13 photographs here listed that you gave me, and Q8C is not one of them.
No, what I'm saying is, the number 13 here from Chuck Morton's very quick review this morning of the boards, comparing them to a list that I received last night from Aaron Schulberg. What I'm simply saying is that this is one that Mr. Morton apparently missed in his very quick review this morning, but it's not on Myron Schulberg's list. The additional problem, Your Honor, with this exhibit, which I'm going to ask the court to consider, is the problem where we have photographs which were originally K7s, which are now called Qs. And when
So
we-
you don't have Q8C, is that the one?
Correct. That's correct, Your Honor. But then we have the
How are
addition.
we determining what we do or don't have?
Just hearsay from Mr. Schulberg.
What?
This is hearsay from Mr. Schulberg,
And how do you know that what Mr. Schulberg's referring to is what you think it is?
which is why I asked where Mr. Schulberg was, but we'll determine that. But I want to know which are the contested photographs before we go any further. All right, let's see the next board.
Just the other problem again was these two photographs, Your Honor, on that one, that's all.
Not interested in that issue right now.
Okay. This was the board that Mr. Morgan didn't actually see this morning because it was being photographed. So there were 4 additional items that are not on Myron Schulberg's list that he gave me last night. They would be Q10, Q13, Q18, and
Q10, Q13.
yeah, and Q18. And then there's this problem, which is Q47 here is a hair from the knit cap. The Q47 that Mr. Schulberg gave me, he said was a fiber, not a hair. I'll just have to get clarification on it. That's all I know.
All right, let's see the next board.
I mean, that's one of the problems with
Next. Here's another Q47.
that's the one, that would make sense. But that's the fiber that Mr. Schulberg was talking about.
We have the second Q47.
We do not have K18. Never got K18. We do not have Q3B. We do not have Q1. We do not have Q8B2. And we do not have Q7C. But we do have Q47 fiber.
And the Q47 on the known head hair from the defendant
We do not have.
was in fact a hair.
Yes.
So you have 240 Q47s. All right, next one, Mr. Escobar. All right, this is known fibers from knit hat and Nicole Simpson's dress.
K-47 is actually the known standard from the Blue Academy.
So K-47 is incorrect.
No, that would be correct.
All right, counsel, Mrs. Robertson advises me that Mr. Schulberg is on the phone and is advising the court through Mrs. Robertson that there is some confusion as to the numbering and which photos he has and does not have. We're going to take a brief recess. I'm going to ask counsel to consult with Mr. Schulberg, get an inventory of what he had, what he didn't have, and let's get this clear. All right, we'll stand in recess. All right, back on the record. Counsel, have we had the opportunity to clarify which photos, who has what photos?
Yes, Your Honor. Mr. Schulberg confirmed the correctness of the list, That, he called because he was concerned about why photographs were being used at all. And he thought there was confusion about photographs. But there is one other problem here, which Mr. Morton pointed out. What they're calling K47 is actually a known fiber from what has previously been called Q47. That K47 on the FBI reports is in fact a standard from Colin Yamauchi. So it's actually mislabeled there. You see what I'm saying?
Yes, counsel's correct. It should read Q47 parentheses known. That's our fault.
Right.
That's why I was explaining to the court yesterday. You know, the labeling was not completed on these until yesterday afternoon, and on some, Jonathan informed me this board has not been corrected yet. As you can see, there are patches on them. We had to relabel a lot of things because they were incorrect because there were so many items, which is what was a delay in getting these to the court. So that will be relabeled if we're permitted to use it.
So then it's the K17 and K47, though, that we did not have, which they call, I'm sorry, well, we knew it as Q47, okay?
You know it as Q, but you have the photograph. All right, Mr. Escobar, next matter, next board.
Yeah, I can't answer that question, based on what I know. Mr. Morton and I step up again, Your Honor?
Yes.
Thank you. Your Honor, he was given a photograph of K14. He was not given the photographs of K9. And then on the... Right. We have the two Q3Cs on the left and right side, Your Honor, but not the electron microscopic photograph in the middle. That we never received. So in other words, neither of those electron microscopic photographs, K9, or the one that's Q3C in the middle, wherever disclosed. Your Honor, Mr. Morton's also brought to my attention that the Q47 fiber we had is the fiber from the knit cap listed here, not what's listed as K47 on the previous board, which is really a known from a Q47. So we hadn't those photographs either. This is the only Q47 we did have.
All right, you don't have Q3C and K9.
We have the Q3C on the far left, but not the Q3C in the middle, which is the electron microscopic photograph of Q3C. On this board, they're both labeled Q3C.
Got it. All right, this is the bluish-black cotton fiber associations.
We do not have Q3B. We do have Q23. We do not have Q27. That's it.
Okay. All right, this is known cotton fiber from Ronald Goldman jeans. question cotton fibers from Ronald Goldman's shirt.
We have Q23, we do not have K19.
All right, thank you, Mr. Escobar.
We don't have Q3A. Yeah, Mr. Morgan believes he didn't actually see this board either because it was being photographed. We don't have Q3A nor Q21.
All right, thank you, Mr. Escobar. Briefly.
Very good. Of the photographs on the boards, the ones that they complain of not having are all accompanied by photographs they do have and have had since September of '94. Q1 is on the same board as other photographs, questioned hairs that were photographed that they did have. Q8C is on the, again, same thing, on the same board as photographs of hairs that they did get. Same thing for Q10, 13, 18, and 47, on the same board with photographs that they did get. Q8B2 and Q7C, same issue, on the same board as photographs that they do have. With respect to the blue-black cotton fiber that we heard so much screaming about yesterday, in fact, they did have a photograph of that. Q23, they have photographs of Q23, which is on the board with other which is photographs they do have on the same board with photographs they claim not to have. The issue here is that the defense clearly knew as of September of '94 that photographs of the microscopic comparisons were taken. They had them in their possession and have had for, what is this now, 10 months? So they were on notice that such photographs were taken. We decided to present them on the form of boards and presented them to them the day before. And now we hear there are some photographs that they do not have. They've had the opportunity to examine them. They've had the opportunity to photograph them. There is nothing else that could be done to provide them with discovery and time to examine it. But the bottom line here is that they were on notice that these photographs existed. And if they were concerned that they wanted to provide their own photographs, they certainly have had ample time to create them and access, having had the evidence in their hands for at least 3 occasions, on 3 separate times, with all of their experts. And knowing that photographs had been taken by our experts, what stopped them from taking their own photographs? And how can they complain that there were some photographs that they didn't see that are on boards with photographs that they did see? All right, now you've seen them. You've had a day to absorb it.
You were just making some observations
That's
regarding
it.
the associations.
Anyway, that's it.
All right, thank you.
I did want to point that out, but let me say this, Your Honor. To preclude evidence that is important to the proof of the elements of the crime would unfairly punish not just the victims, but the people of the state of California. And I do point out to the court the families of Ronald Goldman and Nicole Brown Simpson. To preclude that kind of evidence in a case, and it is important evidence, Your Honor, not willfully withheld, not knowingly withheld, and the court knows that, and even the defense knows that. It has been turned over as soon as we found out about it. It penalizes the wrong party. If the court feels that we have been remiss, then I would urge the court to penalize us personally, or myself personally. But please don't penalize the proof of the case.
Your Honor, with regard to that last remarks of counsel, the district attorney's offices are the representatives of the people, as we all understand. They're representing the people. They're representing the victims. They're representing everybody. They represent OJ. They represent the innocent as well as the guilty. That's what justice is all about. And when they do something in this case, as they've done, they have to be held accountable. It's fine to make that kind of a speech, and the court's going to have to weigh that. When Your Honor recited what you would do in this case, you were mindful that would apply. You weren't just saying that applied to the defense. It applied to both sides. So we can't carve out an exception for the people just because they want to say, well, we messed up and we don't want this to neuter the detriment of our case. When a lawyer makes a calculated decision and they are caught in that decision, they're held responsible for that, and their case does suffer whatever. Because you see, it's not just the people. It's the jury. It's everything. It's justice. It's the defendant and his right to a fair trial. And the only thing I wanted to say in response to what she'd indicated, you've listened to us enough, is that we, based upon the errors we've seen on this board, we want an opportunity to look at the microscopic slides in addition to these photographs. I mean, it's not, we're not going to take their word for those things, Your Honor, and I think you can see there are enough errors here that there are problems with regard to this, and we just can't accept their word for what's happened. And we tried to point that out in the course of our remarks. And so you've heard it, and I'll submit it, and I've expressed to you how we feel about this.
All right. Thank you, counsel.
And I don't want you to be misled. The errors are ours on the labeling, not Mr. Dietrich's.
I understand that. All right, the court has before it two particular issues: the late disclosure of photographs that the prosecution hopes to offer before the jury. The court also has before it the content of a report regarding investigation into the source of the carpet in the Bronco automobile, which speaks to the relative rarity of that particular carpet, that particular formulation and color and date of manufacture. I'll address the photographs first. The court will overrule the objection to the photographs for the following reason. The defense has had access to most of the photographs. None of the photographs that are in dispute depict items that other photographs of which do not similarly exist. The defendant also had access on at least 3 occasions to each piece of the physical evidence that the photographs depict. So the objection on that basis will be overruled. The objection to the content of the report prepared by Mr. Diedrich regarding the source and rarity of the carpet fiber, that objection will be sustained. The prosecution will be precluded from presenting any evidence that is contained in the report. All right, let's have the jury.
One clarification on it. With respect to Agent Diedrich's conclusion that the Bronco fibers are consistent, which was contained in his report, that much is admissible?
That is admissible.
All right.
For those questions posed, can the counsel approach the bench so we don't have any misunderstanding on that? When we get to that point, I'm a little concerned about, so there's clarity. We've had some.
Trust me, all of our antennas will be up when we get to that.
And I would think so. You know, there's one other thing we would like to bring up.
The ruling is very clear.
Well, we hope so, Your Honor. But, Your Honor, with regard to, would the court entertain our a proposed jury instruction with regard to this delay and what's happened the last half day or so, as you've done in the past? Professor Ullman is here, and rather than take the time now, we'd like to be able to proffer something to you as to what occasioned this delay and what's happened for the last half day.
Would have been nice if you had asked before I invited the jury to rejoice.
Oh, no, well, let me just suggest this to you. I had to hear what Your Honor's ruling was going to be first, and I'm not. Professor Ullman is here, and we want to get this case underway. What I was going to suggest to you is that if we drop something, will your court entertain it, or we can do it real fast right now? I think it's appropriate.
You can submit it to me. I want to start with the jury, though.
Sure. No, that's fine. I'm not asking you not to start with the jury.
I'll consider it, is what I'm saying.
Okay, that's fine. We'll do that and get it to you as soon as possible.
Let's have the jurors, please. Let the record reflect we have finally been rejoined by all the members of our jury panel this morning. Good morning, ladies and gentlemen. As you recollect, yesterday we ended a little early because there were several things that I needed to take up with the lawyers, and we spent a long time yesterday, and it spent a long time again this morning. I apologize to you for that. Unfortunately, these things happen during the course of the hard-fought trial. All right, Ms. Clark, people may call their next witness.
Thank you, Your Honor. Good morning, ladies and gentlemen. People call Mr. Douglas Diedrich.
You do solemnly swear that the testimony you may give in this house not to before you support should be the truth and whole truth and nothing but the truth to help you God?
I do.
Please have a seat in the witness stand and state and spell your first and last names for the record.
My name is Douglas W. Diedrich. Diedrich is spelled D-E-E-D-R-I-C-K.
Ms. Clark.
Thank you, Your Honor. Mr. Diedrich, can you tell us where you're employed?
I'm a special agent with the Federal Bureau of Investigation. I'm currently assigned at the FBI laboratory in Washington, D.C.
And how long have you been with the FBI, sir?
Well, I've been with the FBI for 23 years, and I've been working in the laboratory now for a little over 17.
What is your current assignment?
Currently, I'm the unit chief in the hairs and fibers unit of the scientific analysis section. I've been the unit chief for approximately 2 years.
What are your duties as unit chief?
Well, as unit chief, I'm responsible for supervising other special agent examiners, support examiners, and physical science technicians. I review reports that they compile. I provide protocols and information regarding the operations of the unit. I supervise various programs that are undergoing in the unit, such as skeletal remains. We have a DNA program that we're currently researching, and other matters that deal with evidence submission and evidence examination.
Approximately how many employees do you supervise, sir?
Thanks. I supervise about 20 employees.
Are they all hair and trace examiners?
Yes, they are.
And what is your education?
I came into the FBI in 1972 with a bachelor's degree in biology from Indiana University.
Can you tell the jury what you've done with the FBI over the past 23 years?
Well, in 1972, I hired on with the FBI as a clerical employee, and I was a file clerk. I gave tours at FBI headquarters for several years, and then I went into new agents class in 1976. After completing new agents training, I was assigned to New York City as my first office, where I was involved in fugitive investigations and other matters. In late 1977, I was reassigned to the laboratory division into the hairs and fibers unit, where I had 1 year of training, and after that time became an examiner. Since that time, I've primarily been an examiner in the unit.
And you continue to examine as part of your duties?
I do.
And by examine, we mean hair and trace submitted to you in various cases?
We get evidence submitted to the FBI laboratory from local and state law enforcement agencies around the country and around the world. We also do support work for FBI field operations, such as investigating bank robberies or kidnappings, hijackings, extortions, a number of investigations that we're responsible for as a law enforcement agency. We may conduct examinations in those cases.
So it sounds like all kinds of cases.
Well, there are a number of violations, federal violations, that we may get involved with, and from the standpoint of local and state, most of our work deals with homicide investigations, sexual assaults, aggravated assaults, and other matters that are primarily the concern of local and state law enforcement.
So you're testifying in this case, it's a local case, right? This is not a federal case, is it? It's a state case.
It's a state case, right.
Is it unusual for you to be testifying in a state case for a local agency?
No, probably most of my testimonies have been in state court.
Now, approximately how many cases have you examined in the lab?
Well, I've examined probably 4,000 cases since 1978. That's about when I finished my training. I've testified in maybe 400 of those cases. So about 10% of the cases that I work involve some form of testimony.
And in those 400 cases in which you have testified, have you qualified as an expert in the field of hair and trace examination?
I have. I also do feather examinations, and I do some wood examinations too, but it's trace related.
Have you always testified for the prosecution?
No,
You have testified for the defense as well,
maybe 25 or 30 times.
whenever they ask you to?
They request it. Sometimes the evidence that I look at exculpates or indicates in some way that the defendant in the case may not have committed the crime. And in that instance, or in those instances, I would go and testify as their witness, which I have.
Have you been involved in any training duties in the unit?
Well, as a unit chief, I kind of added on the training coordinator responsibilities, which I had already had prior to becoming unit chief. So I am responsible for making sure that the training programs implemented in the unit for all the technicians as well as the examiners are complied with and the requirements met. I also teach at the FBI Academy. I teach, I haven't taught new agents yet, but I have taught National Academy individuals, law enforcement individuals who go to the FBI Academy for a 15-week training period. I have lectured them. I have lectured in-service training for agents in the field. And also I teach Introduction to Hairs and Fibers, which is a 2-week course that we provide other law enforcement agencies and other laboratories and how to do hair and fiber examinations.
Now, do you provide technical assistance to other agencies or institutions?
I do. I have been involved with training other individuals that are interested in hair and fiber type examinations. I've trained people from the CIA, from the postal inspectors. I've worked with people from the Air Force, the Navy, NASA, Smithsonian. Quite often the Smithsonian will come up with some interesting artifact and they want some expertise on maybe hairs that are recovered or fibers that are found to determine the authenticity of a particular item. They may, and they have in the past, come over to the laboratory and I've done examinations for them.
Now, have you made any presentations at international symposiums?
I have. I've made 2 presentations in Mexico at Forensic International Symposium.
And what was that concerning?
Well, that was primarily the significance or the value of hair and fiber evidence to promote it, in a sense, to show the value of it to these investigators so that they may incorporate that type of analysis in the investigation of crimes in their areas.
Do you collaborate with other experts through forensic associations?
Yes, I have attended meetings down at the Academy. I went to the 1985 International Hair Symposium, sat on a committee there. I also I have attended a technical working group for fiber examiners, which is at the Academy. And it's made up of individuals from around the country who are interested in developing knowledge about fiber examinations. I've attended the European Fibers Group meeting in Sweden just recently, and again, that's working with the Europeans on the same type of work. But collaboration is part of growth, and it's part of learning more about the field that we're working in.
What are, you indicated that you are involved in some training. Is there a training committee that you're involved with?
Well, there was a training committee that was established to establish guidelines for the new examiners that are coming on board around the laboratory to make them more uniform throughout the lab. And I was designated as a member of that committee to establish those guidelines. In the past, I have been involved with committees that have essentially supervised the training and during the whole year of their training to make sure that the requirements of that unit were met, and it's sort of an outside review as opposed to an internal review.
So you designed the training program?
Well, in the unit, I designed the hairs and fibers training program, both for the technicians and for the new examiners.
Have you ever heard of proficiency tests?
Yes.
Do you administer those in the course of your job as unit chief to your employees?
I designed the proficiency test relating to hair and fiber examinations for all the examiners in the unit. They take 2 tests a year. I have one of the examiners make tests for me so I can maintain some proficiency. Working cases helps, but it's just a way to check. We do have a blind testing program which comes out of Quantico at the academy, at the training division, where cases come in from field offices or other agencies. They look like a regular case. They're worked as a regular case, and then they're reviewed. They're sent back to Quantico for review to see if they were done properly, if they were done in a timely fashion, just to review the accuracy and timeliness of the case.
In that situation, then, you're being tested, but you don't know it.
You wouldn't know it. No, as an examiner, you wouldn't know it.
Well, what if you make a mistake on one of those blind tests? How do you find out?
Well, the blind test results are returned back to the unit chief for review. The unit chief will then determine if the case was done properly. I would review the notes of the case to make sure they were done. No recommendation is done at this particular time. I then return that to the training committee at Quantico, who then makes final determinations. Yeah, we are involved in external training as well. We have been taking external tests from the European Fibers Group and from other groups over the years.
By external tests, you mean?
Well, an external test is a proficiency test that is provided from outside your own group, such as the European Fibers Group over the past couple of years has sent tests out that we've worked with and sent back a response. In the past, and I can't recall how many years ago, I think the English were sending around a test, and I was asked to take the test for our unit, and I haven't heard any results on that.
What does that mean? You haven't heard any results on that. Is there any significance to that?
Sustained.
Let me ask you, sir, if you know. When you're tested either through a blind proficiency test in which you don't know you're being tested by Quantico or by an external test, are you notified if you've made a mistake?
You become aware of it, yes. They'll let you know. And the purpose of these tests, whether they're internal, external, or blind, is to see if anybody is having a problem. If somebody is not making the matches that they should make, if they make the proper associations or not.
Sustained.
May I lay a foundation, Your Honor?
Proceed.
So if you are notified if you make a mistake. You are made aware of that.
That's the purpose of...
Oh, proceed.
The purpose of proficiency test, as I said...
Ask another question.
Did he answer it?
Question, are you notified, yes or no?
Yes.
Are you notified?
He's answered the question.
And the answer was yes? Okay. Have you ever been
Yes.
notified, sir, of having made a mistake on a proficiency test?
No.
How about anybody else in your lab?
I have no record of any such mistake being brought to my attention. We've been involved in proficiency testing in the laboratory since 1986.
And since 1986, when proficiency testing began, you have not had any mistakes brought to your attention
No.
made by anyone?
No, and in the last few years, I've been grading the test as well.
Now, earlier you used a term, and I'd like to ask you about its scientific propriety. When you make an examination of hairs or fibers, and you attempt to compare them to see if they are the same or similar composition, do you ever use the term match?
Well, sure, we use the term match.
And when you use the term match, what do you mean?
Well, a match indicates that the question material and the known material exhibit the same microscopic characteristics. With textile fibers, they may also exhibit certain optical properties which are also the same. When I say match, we cannot say with absolute certainty that a fiber originated from a particular fabric. It's not possible to do that. Nor do we say that a hair that's found at a crime scene or in a proficiency test originated absolutely from that individual. Now, on a proficiency test, you know it did, because that's the way the test is designed. You have a known sample from an individual, and you have a question hair. Now, the question hair, I know, came from that person. That's a fact. But the most an examiner can say about that hair is that hair could have come from that person if it exhibits the same microscopic characteristics. It's a fine line, but we only say could have.
Okay.
Please, according to you, that explanation, because
Your Honor,
match
are we
has
having
plain
speaking
English.
objections now?
Sustained, counsel. Sidebar with the court reporter. Thank you, counsel. Proceed.
All right.
We're talking
In-
about proficiency tests.
In casework examinations, what is the habit and custom in your lab concerning review by other examiners? For example, if you have a case and you draw conclusions about what you've seen in the course of your comparisons, does someone else review that as well? Do they just review your paperwork, or do they review the actual items that you compared?
Well, with regard to all hair associations, that is, when an examiner says that this hair exhibits the same microscopic characteristics as a known sample from an individual, and that's what's being reported, another examiner will take a look at that same hair association and determine whether or not it's valid. If that person signs off on it, then the report will be reported out. It will come to my desk. I review all the documentation that's done in the case, not only just the hair association, but any other work that's been done, such as if all the fiber tests have been conducted properly, if all the requested examinations have been answered, if all the items are correct, and so forth. So I'm kind of like the last stop in the laboratory for the report before it goes out.
Now, is there anyone in your unit that has as much or more experience than you do?
No.
Who next to yourself, in terms of years and experience, is there?
Well, we have two examiners that have approximately 6 or 7 years of experience, caseworking experience.
And yet, you've indicated to us that you have your casework confirmed by someone in your unit as well, correct?
Sure.
And why?
Object, you're saying.
And why would you do that if they don't have as much experience as you?
Well, I don't have any doubts in the abilities of any of our examiners, our qualified examiners, and their ability to properly associate hair evidence. They wouldn't be doing cases if I had any question about that. After a year of training, you get a pretty good idea as a training officer or as a unit chief as to the abilities of someone to make the proper call. Once they're qualified, they have an opportunity, as with any examiner who has any number of years of experience, to confirm or not to confirm hair associations that someone else has made. I would have them look at my work just as they would have me look at their work.
And did you do that in this case?
I did,
Someone reviewed all of your work?
yes.
How many hair comparisons have you done over the past 17 years?
Well, each case that comes in, and a case being evidence submitted in a criminal violation, may contain a lot of items. I really don't know exactly how many the average is, but 10 to 20 items of evidence submitted in a case is not unusual. That would be items from a suspect, items from the victim, items from the crime scene. So all of these items have to be processed for hairs and fibers, and you have to examine all of those. So there could be hundreds of examinations and comparisons conducted in each case. So if you multiply that out, that's a lot of hairs and fibers.
There were, you said, about 4,000 cases?
About 4,000 cases, yes.
So 4,000 times 100, 400,000 comparisons?
I would say 500,000 would be reasonable. I feel like I've examined actually a lot more than that, but 500,000 sounds all right.
And that's for hair and fiber combined?
That's both.
Okay, let's talk about the composition of hair. What do you use to examine hairs?
Well, hair examinations are conducted with the microscope, either a research microscope, a stereo binocular microscope, or a comparison microscope.
And what can you tell from the microscopic examination of hairs?
Well, the first thing that you have to determine with regards to hairs is whether it's an animal hair or human hair. And if it's an animal hair, if it's important in the case, it can be identified through reference collections, confirmed through reference material, but also the first step is just what's in your own head from your own knowledge. With human hairs, the race of the individual, the part of the body the hair came from, how it came out of the body, if it's been artificially treated, if it's been subject to some disease or some damage. And these are the first things that have to be determined on every hair that's examined under the microscope.
Okay, with regard to those first things that you look for during your examination of a hair under the microscope, you indicated how the hair was removed.
How the hair was removed. Hairs can be naturally shed. They would have a root that looks like the head of a wooden matchstick. It's kind of rounded, looks like a club shape. If it's forcibly removed, as is the case sometimes with the matters that I look at, the hair, which is firmly attached, will be pulled and it will stretch. It'll look all stretched out, and it may even have some tissue from the follicle or from the area of the skin where it's attached. That's forcible removal. If the hair has been pulled, it may also break at the skin line. It may tear. It may be cut with a dull or sharp instrument. These are things that can be determined microscopically.
Now, there are then, you were referring to these microscopic characteristics. Are there specific characteristics of hairs that you use to compare when you do your examination?
There are a number of microscopic characteristics that I look at and I consider and compare in every case.
Would it assist you in your explanation of those characteristics to the jury if you were to refer to a diagram?
That would be wonderful.
People's 459, Your Honor.
All right, People's 459.
You know what? Okay, we see before us, People's 459, a diagram. Are you familiar with this diagram, sir?
I am.
How come?
I prepared it.
All right. Since you prepared it, you can explain to us what you were trying to indicate on this chart with respect to the microscopic characteristics of hairs.
Be glad to. The hair shaft is actually what you look at under a microscope, first of all. Under low magnification, it shows the root area. Also diagrams out the follicle, or the area of the skin where the hair is growing, the hair shaft, and the tip of the hair. Each of these areas all have characteristics and have a particular look about them that is useful when comparing hairs between a crime scene and from an individual. Now, the enlargement beneath it shows an area of that hair that is magnified. Always keep in mind that these diagrams are two-dimensional structures, or two-dimensional pictures. You're not seeing that they're in fact cylinders. Hairs are cylindrical type objects, and this is only looking at one particular plane. The examination involves what's called optical cross-sectioning. By focusing up and down with the microscope, you actually look at all the characteristics from the bottom of the hair as it's laying on the slide to the top of the hair. Now that diagram shows that the hair has an outer layer of scales called the cuticle. Now these scales always overlap in the direction of the tip. Any abuse, damage, blow drying, being in a dry environment, all affect the way the scales will protrude away from the hair shaft. Some individuals, they lay very close. Other individuals, they're separated to a great extent. So the degree of scale protrusion is a consideration. Now, this is colored for your enjoyment, I guess. It's actually not brown. The color of the cuticle is something that would be considered. For instance, if a person treats their hair, if they dye their hair, or even if they alter the color in some way, it's possible to determine when that treatment may last have been applied by considering the length of growth of that, the length that the hair has grown since the application of the treatment. So about a half an inch a month, you get an idea how far back the treatment was applied. This may be important in a case, depending on the circumstances. Now, the cuticle can be very thick, it can be very thin. It may have a very distinct border underneath it. Other times it looks like it blends very evenly with what the underlying structure is called the cortex. Now, most of the hair is called the cortex. It's kind of like a pencil, all right? The paint on the outside of the pencil is the cuticle. All the wood, that's the cortex. And the lead portion of the pencil, that's the central structure called the medulla. Now, in the cortex, there are pigment granules. They help to give the hair color. The pigment granules can be different sizes and shapes. They could be distributed in certain ways within the hair. In black people, the pigment granules are tightly grouped and often very dense. In Asians, the hair, the cortex may be quite a bit larger. It may have a reddish coloration. In Caucasian individuals, you have a pretty good range. The distribution of the pigment is a consideration. Red-haired people, the pigment's always grouped down towards the middle, down towards the medulla, but most everybody else, it's grouped outside towards the cuticle. All right. Now, also in this cortex, you'll have little air bubbles. They're called cortical fusi. It's a scientific term, but they're just little air bubbles. And these little bubbles can appear in different sizes and shapes and different places of that hair. It would be something to look at and consider when you're comparing a question hair with a known hair. Now, sometimes the pigment is found in large groups, and it looks like a solid structure, and it's called an ovoid body. Now, some people have a lot of these. They may be all black. Some people have amber-colored ovoid bodies. They could look like little footballs inside the hair shaft. Or they may look like circular structures. It just depends on the individual. If they're there, how many of them, where they're at, it might be something that is characteristic of that person's hair. Now, in the center of the hair is called the medulla. It may or may not be present. In head hairs, sometimes you see it, sometimes you don't. With Asian individuals, the medulla is often very thick and continuous. If it looks black under the microscope, and I believe in this diagram it looks black, that's because there's air surrounding that area of the hair, and the light from the microscope won't get through it. So it may look black. Sometimes there is no air. It'll look clear. It just looks like a clear river running down the middle of the hair. Now, it may be continuous. It may be broken. It may be in large lengths, or it may be in small groups, and there just would be a consideration of the appearance of that medullary structure. That's about what hairs look like.
Well, based on what you're saying then, sir, these characteristics of the cuticle, the cortex, and the medulla are vary between individuals.
Well, yes, they are. Yes.
Would you be able to draw for us some of the ways in which you've seen it vary?
I'd be happy to.
We could do this here so that the council can see what's being drawn at the same time.
I certainly can. I think
Right.
if I can get it from the jurors that proceed.
Well, we need to get as many people at one time to see this. All right, 165, can you see that?
Yes, sir.
All right, thank you. Proceed.
Thank you. What color would you like?
Well, black is fine.
There's also a thinner one here.
Ms. Clark, what would you like Mr. Diedrich to draw?
What would you like to draw first?
Would you like me to step down and draw for you, please?
Yes, I would like for you to step down. Thank you.
Now, we talked about the diagram I'm just going to redo this a little bit for you here, just so we can fill in the blanks. That's that magnified area of the hair shaft. The cuticle is the outer structure. And again, consider this to be a cylinder or three-dimensional structure. The scale protrusion may be great, or it may lay very, very flat. You might not even be able to see where the edges of the scales lie. Again, the color, the thickness of the cuticle. The pigment granules appear to be dots inside the cortex of the hair. Now, with gray-haired individuals, you won't see them. If a person bleaches their hair, you'll see them. They'll just be light. Pigment granules can be in groups. May help to define the racial group. Clumping of pigment into groups within the hair shaft is characteristic of black individuals. But not all black individuals have heavy clumping of pigment. Some do, some don't. When I speak of microscopic characteristics, we go from models. Always go from a model. We have a model for the Caucasian. We have a model for black individuals. We have a model for Asians. But they don't always follow the model. However far they go away from the model, that makes it a little more difficult determining race.
And sir, why do you determine race? What's the point of that?
Well, race is determined primarily for investigative purposes. That's the first stage. You may have a hair that's recovered on an item of evidence in a case, and they want to know who may have committed the crime. From an examination of the hair, some direction may be given to the investigator by the lab examiner. Might help them in determining who they should be looking for, perhaps. The bottom line in our work is comparison. You may be a little off in saying the exact racial group, or maybe...
Well, I was going to ask you about limb hairs. Let me ask you that later. Right now, can you please tell us, sir, how you conduct an examination of hairs?
Well, back again a little bit here. The first thing I do, once the hairs are prepared on glass microscope slides, is to examine the hair to determine animal, human, racial origin, and part of the body it came from. I do that with all the question items. The question items may be from the clothing of the victim, and it may be several items, and they're all mounted on separate slides. The clothing of the suspect, again, they're mounted on separate slides. I go through, starting at Q1, question item number 1, and I move through the case, getting an idea as to what kind of hairs I'm seeing on the victim's clothes, what kind of hairs I'm seeing on the suspect's clothes. I then go to the known hairs, I examine the knowns, describe them in note form, but the notes are taken just for me to make sure that I look at everything, and also to highlight some of the characteristics that are being seen. And ultimately, take the question hairs using a comparison microscope and comparing them with that instrument.
All right. Would you please describe the process by which hairs and fibers are mounted on slides?
Sure. The hairs and fibers that are recovered from the clothing of an individual are often retained in either paper folds or in plastic pill boxes or however. That, let's say a pill box, is taken to a stereo microscope and then examined carefully to see if there's anything in it. Are there hairs in it? Are there fibers in it? What else do I see? And then those hairs are removed individually. Now, before you start even working on this, that whole area is cleaned off, and you make sure that there's nothing on it that's going to be added to your case. A clean glass microscope slide is placed down on some clean paper. The hairs are then removed individually and mounted on that slide. First thing I do is I place a thin film of a solvent called xylene, and it allows the hairs to stick to it.
May I interrupt you, sir? We have photographs. Would you like to narrate the photographs so the jury can see the process?
That would be fine.
Okay. Can I ask that this series of photographs be marked collectively as People's 461, Your Honor? With,
Yes.
and this would be A?
Yes.
Thank you, Your Honor. Can you please tell the jury what we see in 461A?
Well, we see an examiner that used to have dark brown hair, but he's
that you?
changed a little bit. Yeah, hairs do change a little bit. But what I'm doing here is looking through the stereo microscope and looking at a pill box that contains hairs and fibers that may have been collected from a particular item of evidence. The stereo binocular microscope allows me to look at the material from a three-dimensional look. The mechanics of it, or the optics, are set up in such a way that you're looking at it three-dimensionally, so you can focus up and down and see what's underneath things.
Okay. Can you tell us what's being done in this picture? 461B, Your Honor?
Right, here you see the examiner removing a hair from the pill box in preparation for placing it on the glass microscope slide. Each hair would be measured. I mean, there's a ruler generally laid down for the purposes of determining the length of the hair before it's mounted on the slide.
Now, you're using a pill box there to contain the hair and fiber that you recover from evidence. Have you ever heard of people using paper bindles to contain hair and fiber collected from evidence?
Well, I never heard the word bindle until I got to this case, but we've always heard them as druggist folds or paper folds. So if you want me to call them a bindle, I'll call them a bindle.
You don't have to call them.
Okay.
You can call them paper folds. You've seen that before,
I've
have you?
I've seen it come all kinds of ways.
Is there anything wrong with collecting the hair and fiber that is recovered from evidence into a paper fold instead of a pill box?
No, I think it's just easier to work with a pill box from an examiner standpoint because you can actually see what's in it. But paper folds are fine.
And paper folds are what you received from Susan Brockbank of LAPD in this case?
I did, yes.
Please tell us what we're seeing here in 461C.
Okay, I've already mentioned that once you take the hair out of the pill box, you place it on the slide with some forceps.
Do you ever do that with your hands?
You can use your hands, sure. Yeah, you may have to hang on to the end of the hair when you're measuring it. You just hold one end and hold the other with the forceps, or you can use two forceps. You always have to be careful with forceps because you can pinch the hair, you can break the hair. It's kind of a little delicate operation. But yeah, you can use your hands. As long as your hands are clean, that's not a problem.
And in this photograph, sir? 461D?
Okay, once the hair has been positioned on the glass slide, now this glass slide is like 1 inch by 3 inches, and on one end there's an area that you can write on it as to what you're putting on this slide. You place the hair on it, you blot out the excess solvent with some blotter paper, and you place a few drops of permount, which is a mounting media. It's like glue. It's a yellowish substance. It looks, you don't really see the color microscopically, but it's placed 3 or 4 drops on the slide, and then you lay the cover slip down on top of that.
Now, the xylene that you mentioned before, a solvent, is that the process being shown in this photograph, 461E?
Right, this would have been the step just prior to putting on the permount. Right.
Why is it used? Why do you do this?
Well, it's just used for, well, for one thing, it blends with permount. It mixes with it. You couldn't use water. You would have to use something that would mix with the glue type substance you're using. So you actually just to hold the material in place. If you're working with fibers, you can't put a fiber down on a clean, just dry glass because the slightest air movement could move that fiber off the slide. So you just use it to stick things on the slide while you're taking material out of your paper fold or your plastic pill box or from a hatchet or whatever you're taking it off of, just so you don't lose it.
Does either the solvent, xylene, or permount affect the hair or fiber in any way in terms of its appearance? Does it alter or damage it?
No, it just allows you to see it better.
Let me ask you about that. if you were to examine a hair or fiber mounted on a slide with water instead of per-mount, would that be a good or bad thing?
I wouldn't do it.
And why is
I wouldn't
that?
recommend it either. Well, because there's too much contrast. If the hair or the fiber or these other materials have properties that are not very clearly visible when you use water. You could use some other materials too, but if the properties of that liquid are such that it's quite a bit different than what the item you're looking at is, you'll have a large amount of contrast, and you won't be able to see actually inside the characteristics of that material.
Might the use of a water mount also inhibit or affect your ability to determine how many hairs you have on a slide?
Well, very easily, especially when you're using cover slips, and that material could move very quickly over to the edge, and you would be near the edge of the cover slip. You wouldn't even know it was there because there'd be so much contrast. But even if a hair might be laying right next to another hair or on top of it, it may even look like an extension of the hair. You really couldn't even see that, whether there was one hair or two hairs or however many.
Prior to beginning your mounting process, sir, do you make any effort to determine how long or how short the hairs are that you're going to mount?
Yes, I have that ruler down there, and I measure the hair and put it on a slide and make a notation. Most of the slides that are prepared, I make a note of the longest hair that I place on the slide. Sometimes at a later date, this is may not work out so well because the hair that you find that looks like the individual known standard may be shorter than that measurement that you got. You might say under 6 inches or so on the slide, and the hair that you're looking at is 2 inches. And you have to go back with some thread and try to figure it out, and it works out pretty well. But you can take the slide apart at any time. Well, maybe not any time, but at least during the time you're working with it, because it's still workable. It doesn't set like glue real hard, real fast. You may have trouble like 10 years from now.
Because by then it will be set.
Well, it gets set, right, after about 10 years. It's semi-permanent
So the
initially.
slides that you create will permit the examination and re-examination of the hairs and fibers that were mounted for quite a long time to come.
Sure, and often during the examination, material may have to be removed from that slide so that I may make a crack in the cover slip. Cover slip is just a very, very thin sheet of glass that fits on top of the slide just to hold it in place. And a little tap with the scribe allows a crack to form, and then you can remove carefully the material that you want without disturbing the rest of the slide.
But you would be able to tell then that the cover slip was cracked.
You couldn't miss that.
All right, ladies and gentlemen, we're going to take our break for the noon hour. Please remember all of my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case, conduct any deliberations till the matter has been submitted to you, or allow anybody to communicate with you with regard to the case. We'll stand in recess until 1 p.m. All right, Mr. Diedrich, you're ordered to come back 1 p.m. All right, back on the record in the Simpson matter. All parties are again present. Anything we need to take up before we invite the jurors to join us? Mr. Cochran?
Your Honor, we were not on the record, but at sidebar, we had an indication from the people regarding their list of witnesses to the end of their case, and I'd like to do that on the record if we could at this point, what Ms. Clark told us with regard to not having further witnesses except for Ms. Brown. So we can just make it clear so we know where we're going to go.
Ms. Clark?
That's correct.
All right, Mrs. Brown?
Mrs. Brown.
Yes.
Is possible last witness, and I indicated that there's a possibility that there may be a stipulation if she's interested in that. The other thing, Your Honor, I want to show Ms. Clark something and then just address one of them. What I wanted to point out was just a couple things to Ms. Clark I was showing her. In some photographs we had from them, you remember the issue we talked about yesterday about the photograph of Mr. Simpson that was gone on the board? And I'm not usually one to belabor issues, but in their very photographs, Your Honor, Why are you looking up, Your Honor, like that? I don't understand
Well,
that.
that was a rolling of the
All right,
eyes.
so
is what that was.
the rolling of the eyes. I don't know what that meant. Your Honor, with regard to this, there is a photograph that they wanted to show. There's a photograph right next to it in the book. And I'd like for you to see these two photographs. And it seems to me if they want to be fair, they'd show this photograph in my left hand as opposed to this. They took the one where he looks the worst, and they're taken at the same time. But one is has a scowl or whatever. It just seems to me fundamental fairness would require them to choose one at least to be fair. And that's the thing we're talking about. So would you mind looking at these two
I'll
and
look
see if
at
the
'em.
point is not well taken? I showed it to Ms. Clark, and she indicated she hadn't seen the other. It's from her book, so I wanted to.
All right, I'll take a look at it.
The boards are done, Your Honor. It's all been completed now. I would point out also that, we had a choice between a serious picture, a Ronald Goldman serious picture, and one in which he was smiling, and also selected the more serious picture in his case. But I didn't know there was another booking photograph. But the board is complete, and
When do you anticipate getting to that?
depends on how long.
Well, we're going to go straight through till 3 o'clock. Do you anticipate getting to this before then?
No.
Okay, let's proceed. Let's have the jurors. Please be seated. All right, Mr. Dietrich, could you resume the witness stand, please? All right, good afternoon, Mr. Dietrich.
Good afternoon.
You're reminded, sir, you are still under oath, and Ms. Clark, you may continue with your direct examination.
Thank you, Your Honor. Good afternoon. Okay, when we last left off, you had indicated you had finished telling us about how you mount hairs and fibers on slides.
All right.
And after you complete the mounting of the hairs and fibers, what do you do with the completed slides?
Well, the slides are placed individually on a slide holder in numerical order. From that position, they're taken to a research microscope for examination under low magnification, and then through the whole process.
Now, do you change paper between the preparation of each slide?
Yes.
And were all of these slides prepared in the manner you've described in this case?
They were.
Did you mount all of the hairs and fibers that were found in the paper folds on slides?
I did not.
And why is that?
Well, some of the hairs that were found or fibers that were found were consistent with others that I had mounted from the same material, such as from the gloves. There were some fibers, animal fibers, that were present. I didn't mount those. Sometimes representative samples are prepared from material.
Nevertheless, are all of those fibers and hairs maintained, whether they're on slides or not?
Right. They're either on the slides or they're in the original folded paper.
And so if anyone wants to re-examine them in the future, they can do so, whether in slides or paper.
Yes, they could.
Okay, who mounted the questioned hairs in this case?
I did.
And were the known standards, that is, the samples taken from people's heads and from various cloths, were they mounted using the same procedure you just described?
They were.
And who did the mounting
Well,
of the knowns?
Well, the original known set of hairs was prepared by Susan Brockbank of the Los Angeles Police Department Crime Laboratory. All the other known samples that I received later, I prepared.
Okay, and so then when you say the original known samples, who are you referring to?
That would have been from the defendant and also from the two victims.
Ronald Goldman and Nicole Brown?
That's right.
When Susan prepared those slides of their hair standards, was she in the same room with you?
She was.
Was she at the same desktop with you?
No, she was at a technician position, which is in front of my desk.
And did you observe the procedure she followed?
I did. I gave her some instruction as well as how I would like to see the slides prepared.
And did she do so according to your direction?
She initially started using her own just out of habit, and we decided that it was easier and more time-saving to do them the way that we normally do them.
Now, do you mount more than one hair or fiber on a slide?
Sure.
How many do you usually mount, either hairs or fibers, on one slide?
Well, with hairs, it just depends on the racial origin, the length of the hair, the thickness of the hair, the curliness of the hair. It has a lot to do with it. There could be 5, there could be 3, there could be 15. It just depends upon the hair.
And what do you mean by that? It depends upon the hair. Do you group them?
Well, if a hair is removed from some debris and it's 20 inches long and it's from an Asian, you know it's going to be a big hair. You might only mount one hair on that slide because it takes up a lot of the space. You're only given a little less than 1 inch by 3 inch space to mount that material. But if you have shorter hairs that are, let's say, half an inch long, for instance, from a black individual or from a white individual, you might be able to prepare more. You don't want the cover slip and the per mount to be too thick. Otherwise, it's kind of like floating around in a submarine trying to figure out where these hairs are. You want it to make a pretty flat mount. So it depends on the hair.
Okay, well, at the time that Susan Brockbank was mounting the known standards on slides, what were you doing?
I was looking through the question debris, question material, and preparing slides myself.
Well, what's the possibility of any of the known standards she was working on jumping over onto your slides on the other desk?
No, that's not a possibility. There's too much space in between, and there are no air currents to speak of in that room.
Can you describe that room a little bit?
Well, the room is about probably 15 by 15. There are 2 examiners' positions, and in front of the examiners' positions are the technician positions. So each room will have 2 examiners and 2 technicians, and there'll be microscopes at each location.
So is it common to have 2 people working on slide mounting at the same time in that room?
Could be 4 people working on slide mounting, slide preparation.
Now, after the mounting is completed, what happens next?
Well, once the slides are prepared, they're again laid out in numerical order, and I follow the process of looking at the question material first. I try to look to see what do I find at the crime scene, what do I find on items from the victims, and then I move to the accused or the suspect in the case, and then I look at the known standards in that order. I just want to see first what I have. In the slide preparation, normally the slide preparation goes question material first and then known. And that's to avoid having the knowns exposed.
So you deliberately separate by starting with the questioned hairs and fibers?
Well, you do everything you can to avoid any possible contamination. You're concerned about that. We know the risk that it's involved with contamination. So you take every effort possible to avoid that, so that what you're seeing is actually what was on the item.
And you did that in this case?
Every case is treated that way.
You see a photograph before you. I'd ask that it, Your Honor, be marked 462. This will be a series. Could I ask that it be 462A?
All right, 462.
And I think we already saw this marked as 461, but is this the exam? No, we didn't? This is new. Oh, this is new. Can you tell us what's shown in this photograph, sir?
Well, here the examiner is looking at the slide using the stereo microscope. It may be the first step for some examiners to examine that slide in that way. Low magnification. We start at about, it could be 10x and go up to maybe 40 or 50 times magnification.
Now, in this initial examination, you're looking for what?
Well, if you're looking at hairs, mainly racial characteristics can be distinguished. Length, color, shape, contour, appearance of the tip, appearance of the root. It's easier to see in that instance, perhaps, the apparent shape of the hair itself, the three-dimensional shape of the hair, because you're looking at it in 3 dimensions. But it's just a low magnification screening tool to look through the hairs, to identify which hairs that you may want to look at under higher magnification.
Okay. Is it at this point that you determine, is there such a thing as a hair not suitable for further analysis or comparison purposes?
Sure, there are hairs that aren't worth comparing.
And why would that happen?
Well, there are head hairs, pubic hairs, and some facial hairs are routinely the hairs that are compared microscopically. Hairs from the arm, from the leg, body hairs, for instance, from the trunk of the body, back hairs, eyebrows, eyelashes. These hairs are not routinely compared in forensic laboratories, nor are they compared by us routinely. It may be of some interest in some instances where someone may be hit with like a club hit in the face, and on the club you find eye hairs that are embedded in the club, then that takes on a little more significance. But looking at debris found on clothing or from vacuum sweepings from a floor, they probably shouldn't play a very significant role in any hair identification.
So what is it that causes you to determine whether a hair is or is not suitable for comparison purposes?
Well, if they fall into the categories of the types of hairs worth comparing, it's just experience and the hair itself. You look at the hair, you determine from experience if it's worth comparing, there's enough of the hair to work with, and if it's, again, from that region. And sometimes some hairs are very distinctive. You might not need a whole lot of hair to make a comparison.
So you're looking to have a sufficient quantity of distinctive characteristics?
Well, there's no set number of characteristics that are needed to make a comparison. That's up to the examiner and the experience of the examiner and how many hairs they've seen, what types of hairs they've seen, what is unusual, what is usual. And based on all that, the decision is made to determine to whether or not to compare it with a known standard.
Now, the next slide, next photograph that's on the screen now, 462B. Can you tell us what's being depicted in that photograph?
Well, that's just a close-up view of the slide. It's difficult to see, perhaps, but the slide on the stage of the stereo binocular microscope.
And 462C, can you tell us what do we see in this photograph?
Well, here the examiner is sitting at the comparison microscope, and that's really one of the main tools of the unit. And that's the tool that is used to take a questioned piece of material, like a hair or a fiber, and compare it in the same field of view with the known material. For instance, if a hair were recovered from a weapon or from an item, it would be mounted on a glass microscope slide. Now, that instrument, there are 2 microscopes there. One microscope would be used for the question slide. The other microscope would be used for the slide containing the known hairs from the individual. And by looking through the eyepieces, which he's doing here, those eyepieces will allow you to see both of the hairs at the same time. The same type of comparison is done with fibers. You're comparing question material, known material in the same field of view. More people are familiar with comparing bullets. I mean, I grew up and that's all I ever saw in TV shows was comparing scratch marks on bullets to see if this bullet came from this gun. And they'd line up to striations and you could see them. The difference here is that the material that we're looking at, we're looking actually through it. We're looking inside of it to look at the characteristics because we're using transmitted light and not reflected light.
Now, do you count the number of characteristics that you find in hair samples?
I don't know.
And why is that?
Well, I don't necessarily think there's a minimum number of characteristics that one needs for making an identification. You look at everything. You look at all the characteristics that you see. And based upon all of these things that you're looking at, an opinion is reached based on that. Not on how many notes you take, not on how many points that you write down in your notes. It's actually based on what you're seeing.
So what component does experience, the number of hairs that you've compared and looked at in your tenure as an examiner, what component does experience in that play in all this?
Well, a good hair examiner has a lot of scope time, has a lot of time looking at hairs. The more things you see, the more value judgments you can make regarding what something is worth. We do this every day ourselves in our own everyday experiences, and I just do it from a microscopic standpoint. We value things all the time, and I place value or importance on certain characteristics that I see under the microscope. So the more time you have, the more decisions you can make that are of value. But still, people that come through the training after a year are still going to be seeing a lot more hairs than what many people would ever look at. And within several years, they have a pretty broad base. But I've seen, obviously, a lot more.
Now, as you examine, you talked about notes, sir. As you examine the slides, are you taking notes about what you see?
I take notes on, again, the question items first. I look to determine if there are hairs present, the type of hair, animal, human, race, body area, the condition of the root, approximate length of the hair, how, if the hair had any treatment. I may indicate if it's not suitable for comparison or suitable for comparison. And I just move through the material that way from item to item until I get to the knowns. The known hair slides are examined more, they're examined more carefully at this point because I want to make sure I have a good idea in my mind of the characteristics of this individual. I then can go to the comparison scope and make the comparison. It doesn't take the comparison scope initially. Once you get through to the question material, you have a pretty good idea what the hairs of this person look like, or what the hairs of this person look like, because they're on their own clothes. When you get to the known hairs, you look at the characteristics and the lights go on. I've seen that hair before. I've seen those hairs before. And you just go back through the question material and compare them side by side.
And when you say side by side, you have a chart you're asked to be marked People's 463.
All right, 463.
Can you tell us, sir, what this chart shows us?
Well, it kind of gives you an idea of what you're looking at through the comparison microscope. And essentially, it looks like that first chart you saw with a line drawn down the center. And that's the dividing line between your two microscopes. The best possible match, the one you try to really get, is where you have a mirror image setup. That the hair on the left, which is the known hair, and the hair on the right, which is the question hair, if you looked at them together, they would appear to be one hair. And that's what you try to do when you're trying to determine if a question hair looks like the known hairs.
And that's the field of vision that you have, that circle with a line through it?
Right, well, you can see the hair kind of goes outside the circle, but the field of view is it's a circular field, a white background, and it has a center hairline down the middle, which separates your two specimens or your two microscopes.
Now, is everyone's hair the same? For example, my hair, okay? I almost lost it. We have one hair. If I pull out this one hair over here, is it going to look the same as, say, a hair over here?
With your hair, they probably are going to be pretty close. But with
You're commenting on something?
Yeah, well,
All right.
with most people, there's pretty good range. I mean, there could be a range from you might have a dark hair, a coarser hair on one side, and you might have a finer hair on the other side. That's why we require that the coroner, whoever's collecting the hair samples from the individual, take pullings from different areas of the head as well as combings. Because you got to have a couple things working here. You have hairs that are actively growing, and you have hairs that are ready to fall out. And they don't look the same. They look a little different. So I request that we get at least 25 to 30 pulled hairs and then take combings as well, so that you can get a good idea as to the types of hairs that if they were pulled out, what they would look like, and if they fell out naturally, what they would look like. And use all of these hairs in forming an idea about the characteristics of the known hair.
Okay, so then, is there like a range of characteristics for each person's hair?
There is a range of characteristics, sure. And when I look at the individual hairs from a sample, I determine what the average hair is. You can do that. You can look at them and say, well, I see hairs that pretty much fall within a pretty narrow range, and you're going to have some hairs that are on the outsider edge of that range. But you include all of those into the characterization or the analysis or the storyline that you're writing on these known hairs. This range of characteristics, though, from my experience, is a much narrower range than what you see out in the population, out in other people.
Well, let me ask you to amplify that a little bit more, because if each of us has a range of characteristics, couldn't a hair from the back of my head match the hair from the front of another juror's head or Mr. Darden's? You know what I mean? If there's a range, then why? I shouldn't bring Mr. Darden into hair discussions. I won't do it anymore. You know what I mean? If we all have a range, then isn't there going to be an overlap? How can you say that any hair didn't come from someone else?
Well, as I said, there is a range with each person. Everybody has a range of characteristics. Some people have a broad range. Some people have a lot of hairs that look very similar to each other. It makes it a little bit easier if they're closer together than if they're far apart. But the overlapping aspects, that you might say that a hair that you find on one person's head, it may have some similarities to another person's hair. There may be some overlap, but it won't match. I mean, it may look somewhat similar, but it won't exhibit the same microscopic characteristics.
Strike that word match.
Yes. Jurors to
Sorry.
disregard the term match in this context. Thank you.
Can we replace that term with the same microscopic characteristics?
I meant to say that they won't exhibit the same microscopic characteristics. That is, they won't look the same.
Now, you mentioned, if you looked at that my hairs would probably all look very similar. You're referring to color treatment, correct?
Well, I think the color treatment would be a big help, yes.
And you could see if someone had color treatment in their hair under the microscope.
Oh, very, very easily, yes.
But even if someone has color-treated hair, some kind of treatment with respect to the color, will you still see some kind of a range of characteristics?
Oh, you will, sure. And for instance, some of your hairs may be lighter than others, and they may not have as much pigment. They'll take on a much brighter color than a hair that is darker, that has absorbed the same amount of color. So you will see pigment granules, you'll see medulla, you'll see cuticle, scales, ovoid bodies. You see it all, unless it's so darkly dyed that they're covered up, and that's possible.
So when you mount a known hair standard from a given individual, for example, in this case, the defendant's known sample or Nicole's known sample, do you make any effort to assure that you represent the range of characteristics that you've seen in their sample on the slides?
That selection, yes, I do. That selection is made as you're taking hairs from the container, the original container, whether it's using a stereo microscope or using your own eyes to see length, thickness, color, and a range. I mean, her hairs, for instance, appeared to have some highlighting or treatment to them. Mm-hmm. So and some hairs didn't appear to have too much. So it's just a matter of collecting hairs that exhibited all those characteristics.
so that you accurately represent the range of that person's hair?
Well, the first thing you do is you mount up what you think is a range, a good range, and then you go to your material. You may find a hair on, for instance, on an item of clothing from that person, and you see a lot of similarities with the knowns that you prepared, but maybe something that doesn't quite right. It looks a little different. You may have to go back and mount additional hairs from the known sample, just so that you can increase that range a little bit. You may see something that may not quite be present, and you want to clarify it. You may need to go back and mount more hairs. And once in a while in a case, it happens all the time, that I would call back out to the contributors or the police department and say, I don't think you gave me a good enough known standard, or I need hair combings. Can I have additional hairs so that I can make sure that what I'm seeing either looks like it or doesn't look like it? I want to make sure that before I reach a conclusion that it's a valid association or exclusion.
Now, during the examination of known standards in any case, do you make any effort to see whether you can distinguish between the known standards? For example, in this case, you had the known standards of Ron Goldman and of Nicole Brown. Did you make any effort to determine whether you could tell them apart?
That's the first thing you have to do. When you're looking at known material, you want to make sure that the people you're going to be comparing the question hairs to look different. If they look the same, the conclusions or the strength of the association would be minimized. They could have come from either individual.
Well, has that ever happened?
Not in casework since I've been working. All the known samples that I've gotten over the years, and that there have been quite a few, I've never had a problem being able to distinguish the victims of a case and the suspects of the case, and multiple suspects. I've had cases where I've had 200 or 300 or 400 known hair samples as elimination or possible suspects to compare with question hairs found at a crime scene or on a body of a young child, a victim of a case. And it's a job. The one thing you have to do is make sure they all look different. And it's pretty easy to do.
And you've never had any trouble being able to distinguish between two different people's hair?
No, samples are pretty easy to distinguish. You have some problems with identical twins. Identical twins can be real close, especially if they happen to live in the same environment and they share very many common things. Because environment and diet and how much sun they get, how they treat their hair, all of these things add the differences that are often seen between hairs that may be very close microscopically. A person may take maybe an alcoholic, for instance. We had a case one time where there were brothers. Their hairs looked very close, but one person had...
Okay, this is way beyond the question.
Sustained. Ask another question.
Sorry.
Well, let me ask you this. How many known hair samples have you examined in your capacity?
Easily 10,000, easily.
In the course of that experience, sir, have you ever had occasion to examine the hairs of multiple family members?
I have.
And in that experience, were all the family members were, say, of the same race?
They were.
Same hair color?
No.
How did you distinguish? They were the same. What were they? Were they siblings? Were they mother and father?
I don't think that's relevant to this case.
Both. I mean, brothers, sisters, cousins, aunts, uncles, mothers, fathers.
Were you always able to distinguish between them?
Yes, you can distinguish between them. Sometimes you'll have family members that are pretty close. But for the most part, you can distinguish between even siblings or family members. Again, because
Yeah,
the,
that's what I was gonna
the
ask.
characteristics that I look at are not based solely on genetics. I mean, we know that even brothers and sisters, unless they're identical twins, I mean, they're different. I mean, they just look different. And their hairs also tend to look different as part of this unique thing that we have as a human being.
Well, apart from genetics, is there something about the way a person lives that will make their hair distinguishable from another person's hair?
Sure.
For example?
Well, a person that doesn't wash their hair very much, may have dirt and debris and other material in the hair shaft, underneath the cuticle or the scales of the cuticle. A person may pick up head lice, pubic lice. You can see those on the hair shaft. A person may have also a lot of damage to the hair. It's not a clean hair. It's subject to a lot of damage. This might be characteristic of the type of person that he is or she is.
So, for example, if you got the known standards from two family members whose hair color was the same and who are of the same race, would you be able to distinguish between them based on these other characteristics that you're describing?
Well, hair color and race are pretty broad categories. I mean, if you say brown Caucasian as an example, there's a lot of people with brown hair that are white. I mean, just an awful lot. So that's pretty broad categorization. There are other characteristics that you look for besides just color and racial characteristics, and that's where you see the differences.
Have you been able to distinguish between the hair of two brown-haired Caucasian people in the past?
You do it all the time, in the cases that you get in, as well as the tests that you prepare.
You were mentioning two brothers, one of which was alcoholic earlier. Does that show up in the hair?
Habits, alcohol abuse, drug abuse will affect hair characteristics. There may be characteristics found within the hair shaft that I've seen over the years that may be characteristic of that person's habits. And sometimes they may be the only characteristics that can be used if they're that close microscopically. But hairs are kind of the dumping ground, right? They're kind of the dumping ground of the body. I mean, we have...
Sustained. Ask another question.
Well, you say hairs are kind of the dumping ground. Tell us what you mean by that.
Well, it's a structure that materials are excreted or secreted in so that they can leave the body. A person, as an example, a person has been poisoned, and this has been documented in a lot of cases with arsenic, that by looking at the hair, one can determine that arsenic is in fact present in the hair. If a person is a drug user, the drugs will be excreted or secreted into the hair shaft, and they can be tested that way. And it's a test that is more commonly being used for employment type matters, rather than invade the body with taking blood samples.
Non-responsive, irrelevant.
They take hair samples. So it's just it's a structure of the body that helps the body get rid of things.
Now, in this case, I believe you indicated that you initially got the known standards of the defendant, Ron Goldman, and Nicole Brown, correct?
I did.
And I believe you also testified you were able to distinguish each of their hairs from each other.
I was.
Did each of the individuals, for example, did Ron Goldman's hair display distinctive characteristics?
It did.
Did Nicole Brown's hair also display distinctive characteristics?
They did.
And also the defendant's hair?
They did.
Okay, with respect, I'll start with the defendant first. Did you find, with respect to those distinctive characteristics, at the FBI, do you maintain reference samples of photographs of hairs from people of various racial groups?
We do.
And for what purpose do you do that?
For training, primarily.
Did you bring one of those charts with you here?
I did prepare a chart, yes.
Can you see that? Right, thank you.
May this be marked People's 464, Your Honor?
People's 464.
Thank you. So, are these all photographs that you have at the FBI?
Well, no, I photographed them. Those were hairs of different black individuals, blacks from this country and from Africa.
Okay. So, tell us what you're trying to demonstrate with this chart.
These are hairs that were taken just at random from samples from individuals that were in the reference collection. There's one there from a bushman from Africa, one from a Somali warrior, a couple of them from individuals that work in the laboratory. I think you see there's a blue hair there, I believe, is one of them. That's a treatment. She's a clerk typist in the unit. I think there's another one that has a red coloration to it. And again, I don't recall what type of treatment that was, mahogany rinse or something like that. But the other hairs just represent some randomness, some random variation that is exhibited between different individuals to show you that the hairs do differ microscopically.
Did you also prepare a chart of photographs of Caucasian hairs?
I did.
Is that the next one up, Dana? I'd ask that this chart be marked 465, Your Honor.
465.
Okay, before we move on to discuss this, let me ask you just a couple more questions. You indicated that the defendant's hair was distinctive.
I did.
And what was distinctive about it?
Well, it was very light colored. It had very light pigmentation, prominent one-sided pigmentation, which was prominent in many of the hairs in the sample. There's a number of other characteristics as well. I have them jotted down in my notes, but I felt that those hairs were very distinctive, easy to select.
All right, now you indicated that with respect to Nicole Brown and Ron Goldman, you also found distinctive characteristics, and here we have the board 465. Can you tell us what you're showing us in these 16 different photographs?
Well, there's a couple things, I believe, in this chart, trying to show that there's a variation or randomness to the color, to the pigmentation, distribution, to medulation, or the medulla that you see running down. Some of the hairs have them, some don't. You may find it in a one person anyway. You may find hairs that don't have a medulla and others that do. Again, it's just to show some of the variation. The three pictures on the right I had to bring in. They're my daughter's hairs. On the right, second one, third one, and fourth one, starting from the oldest to the youngest.
Can you step down and show us which ones those are? 'Cause
Sure.
I couldn't tell. You want to use the pointer?
No.
Okay.
This is my 17-year-old's hair. This is my 13-year-old. She was a little upset because her hairs have some damage to it.
She didn't want them on TV?
She didn't want them on TV.
Okay.
And the youngest here has the darker hairs of the three. Again, trying to show that there is some variation even within a family, that they will exhibit different characteristics.
Thank you. All right, so you indicated that you examined question hairs, and then you examine the knowns, and then you go to the comparison process?
That's right.
and you indicated to us the use of the comparison microscope. Let me ask you this. When you compare the question hairs to the question hairs that are recovered from evidence at a crime scene to the known hairs of an individual that were collected, what would you say if only one hair from the known standard exhibited the same microscopic characteristics as the questioned hair?
That's a tough one. It depends upon the hair, how many hairs were recovered, where it was recovered. It may have something to do with whether or not it might be reported. If a hair is on the outer edge of the range, a lot of times those are just thrown out. You don't consider them as a potential. And it's just logic, it's common sense. Here, what would you expect to see if this guy shed hairs at the crime scene? Well, he would lose hairs like most of his hairs. He wouldn't lose, maybe, isn't it just strange that he happened to lose one that looks kind of like one of the weird hairs in his head? I'd throw it out. I'd rather just throw it out and not involve him at all in that type of examination.
So do you try to err on the side of being conservative in your conclusions?
Sustained.
Informing your conclusions how do you have some kind of standard that you go by in terms of trying to benefit the suspect?
Well, it's objectivity, impartiality. You don't get involved with the case. You try to report out truthfully what you see based upon the observations you make, with no concern with the outcome. And it's normally a default mechanism built into it. If there's any question, you throw it out. You don't try to make a match. You either matches or, I say matches again, I'm sorry, it's...
Instruct the witness.
Yeah.
Yes. Ladies and gentlemen, you were to disregard the term match in this context.
You either have the same microscopic characteristics.
You have to apologize because some of that comes out naturally, but if it exhibits the same microscopic characteristics, you call it that way. If there are some differences and you can't account for them, you throw it out.
No.
All right, so for example, well, strike that. We're talking about same microscopic characteristics and when you'll form a conclusion, but let me ask you this, sir. Can you say that a hair found at a crime scene, even though it exhibits the same microscopic characteristics as the hair taken from a suspect, even though you say that, can you say that it could only have come from this person and no other in the world?
No. We do not say with absolute certainty that a hair came from a particular person, no matter where the hair is found.
Are there databases that tell you what percentage of the population could have been the source of any particular question hair?
No.
And when you say that you don't say that, you don't say that a hair could only have come from one person and no other, why is that?
Well, because you can see that in some individuals that there are hairs that can look very similar to another individual. So that in that instance, just because it happens, you can't make a blanket statement and say that it's a positive form of identification. If it happens once, it happens twice, you cannot say absolutely, and we don't say that. Every report that we send out has a statement in it to that effect.
Now, is use of the microscope to perform the examinations considered to be the best method of comparing hairs in the forensic community at this time?
We think so, yes.
Is there any instrumental means of comparison currently recognized as reliable that had gained acceptance in the scientific community other than microscopic comparison?
There have been other techniques, other instrumental methods that have been used, none considered to be useful to individualize hairs.
Ms. Clark, are you going to use 465 any longer?
Not anymore. You want me to take that?
Yeah. Seem to be blocking juror number 7 again.
All right. Let's talk about fibers for a minute. Tell us what a fiber is.
Well, a fiber is the smallest piece of a fabric, essentially.
Are there different kinds of fibers?
There are naturally occurring fibers, such as from an animal. Woolen fibers is a good example. Cotton fibers that come from plants. So plants provide textile fibers. And also there are man-made fibers. And there's some others, but man-made and naturally occurring are the two main groups.
We have a chart here, Your Honor. It's on the screen. Ask if you mark People's 466.
Equals 466.
Can you see the chart, sir? That's been marked as People's 466
I can see it fine.
on your monitor? Okay.
Yes.
Tell us what is shown in this chart.
Well, in the upper right-hand portion of the chart, you see what is depicted as a cotton fiber. And it's probably the most common plant fiber that we wear. And cotton is used for a lot of other things besides wearing, but it's the most common plant fiber. It comes from a seed boll. It's a seed fiber. The fiber beneath it is a woolen fiber. It's an example of a wool fiber taken from a sheep. Woolen fibers can come from other types of animals as well. They don't have to come from sheep. It could come from a woolen fiber from a goat, would be a good example. Camel hair, another one. Cashmere goat is a good example. It's just an example of an animal fiber.
And is that how it appears microscopically?
Well, that's just an artist's depiction of it. Yes, it can. You can see the scales on the outermost portion of the hair. Woolen fibers are hairs, just animal hairs. They look differently microscopically. And some woolen fibers are very fine, not a lot of scale protrusion. They're comfortable to wear. That's what we like to wear. Those woolen fibers that are coarse, that are rough, you might be walking on them. They're not as expensive, so we walk on them. But you wouldn't want to wear them.
And then man-made?
Well, the man-made fiber, it might be a little difficult to pick out here. On the right, upper left, you see what looks like a longitudinal view. If you looked at the fiber underneath the microscope, and the borders on the top and the bottom are the borders of the fiber. All right, and it's just cut off at the ends. It has in it a number of structures that may be found. Delustering particles may be added to the fiber to take away the shininess of it. It's just a pigment that's added to the fiber when it's produced. They may also have voids, or just large spaces with nothing in them, or they may have pigment in them. So these are just examples of what you might see in a man-made fiber.
Down below that, I see shape and cross-section.
Well, shape and cross-section are an identifying characteristic, especially of man-made fibers, because the industry designs and produces their fibers for specific end uses. The carpets that you walk on may have a much different shape and size, or they would, than the clothing that you wear on your body. You wouldn't be wearing a rug around, nor would you walk on lingerie. I mean, it's just not that way. There's a design and a purpose for each of the fibers that are produced, and certain fiber types have certain shapes, and that's depicted there.
So does this chart kind of explain to us what you can tell from the microscopic examination of fibers?
Well, that's kind of the first thing, right? That you can look at and see right off with a man-made fiber or a natural fiber.
Is that like your first determination?
Just like that first determination with hairs. Is it plant? Is it animal? Is it man-made?
John. Your Honor, I have here a chart that's marked entitled Cotton Fibers. I'd ask it to be marked 467.
467.
Thank you. Tell us what this chart shows, sir. Would you
Well,
like to step down and
it
point?
might be easier to see.
Sure. Is there a pointer? It's only the little one.
Ms. Clark.
Please tell us about this chart.
What I've done here is try to give you an idea of what can happen to cotton fibers that you might wear or you may encounter. Cotton fibers, they're pretty common. We make 5 billion pounds of cotton fibers every year, just here in the United States. They go to a lot of different sources. They may go into clothing, draperies, upholstery. There's a lot of end uses for cotton. The distinguishing features of cotton can be seen in the color, whereas a fiber that is uniformly colored would look different than a cotton fiber that had color at specific intervals or different portions of the fiber. The surface color that is seen in this particular cotton fiber would be characteristic of a printed fabric, where the color is added to the surface of the fabric after it's produced. Uniform color might be made or produced when the yarns are coming off, after the yarns have been spun and the whole yarn is dyed. The degree of twist is something that's compared. This is a gray, a greige fiber, like a cotton ball. You may see this particular unfinished fiber in blue jeans. It's a good example. A fiber that is more finished, has been through a little bit more processing, will take a little bit of the twist out. You might find that in a shirt or a blouse. Mercerized cotton has been treated differently. You find mercerized cotton in threads. It doesn't have very much of these what are called convolutions or twists, back and forth twists that is commonly found in cotton fibers.
Thank you. Thank you, Mr. Escobar. This is a chart I'd ask to be marked Peoples 468.
All right, so marked.
Can you tell us, first of all, you told us about the cotton fibers. Now, is this chart about man-made fibers?
Right, it's a little bit of education on how man-made fibers are produced.
Can you explain to us, starting wherever you want? I see the one that the title up to the upper left is cellulosic. What does that mean?
Well, cellulosic refers to the origin, that is, wood pulp, cotton linters, something that has cellulose or material. It's natural as a substrate, as a base material. It's a starting material that you work with.
So cellulosic would mean a natural substance for the starting material?
Right. Some of the first fibers, the man-made fibers that were produced, were cellulosic in nature. That is, they started with something that was naturally occurring. They put some chemicals together and they extruded it into a fiber shape.
Extruded?
Well, if I can step down, I'll point
Please.
that out. Thank you. Okay. When man-made fibers are produced, they have to start with some beginning substance. Some start with a cellulose-based substance. Others start with other chemicals and perhaps even like a plastic chip. They melt the chip and then they make fibers out of it. But from this beginning solution, it is forced under pressure out of what's called a spinneret. It looks like it's a shower head. And this the shape of each one of these little holes and the processing itself has something to do with this cross-section that you see, the shape of the fiber that comes out of it. Dry spinning, it's forced out into air. Rayon, which is the cellulosic, acetate, and triacetates take on these particular shapes. And as they dry, they crimp. And it looks like you have a striated or streaky fiber as it's laying on a glass microscope slide. With non-cellulosics, we see that nylon, polyester, acrylic, monacrylic, olefin would be like polypropylene, polyethylene substance would maybe either melt spun or wet spun. It may be extruded or pushed out of this spinneret into a liquid bath, or it may be again into air. Olefins. They're the types that end up on carpets and many of the fabrics that we wear. You can really control the shapes. And the shapes have a lot to do with how long they last, where they're intended to go, what's going to happen to this fiber, how it's going to feel if you wear it. So these are just examples of some of them. Some of these don't even make anymore. Some are still in production. This particular fiber, as an example, it looks like a dice. You look at it under the cross-section of it. It has 4 holes that run right down the center of it. And the purpose, I'm not sure. Maybe to make it lighter. I don't know. But cost and end use, a lot of these things are included into the factors that make up the fiber that you see. This one has 5 holes running down it. This is called a trilobal fiber. It has 3 lobes. This trilobal fiber, this particular one, has a hole down the center of it. It's quite unusual. These particular trilobal fibers have different shapes and sizes of the lobes, an identifying characteristic of that particular fiber or fabric that you're comparing. Acrylic fibers may end up bean-shaped. This particular fiber here is irregular or round. It looks like it has about 6 lobes. The bottom portion of the chart gives you an example here. It has something to do with why I'm here. And that is the types of fabrics that end up on individuals involved in crimes. Yarn types could be 2 types in particular, a staple yarn and a filament yarn. Staple yarns are made up of a lot of small fibers that are spun together very tight. They tend to shed a little bit more because there's a lot of loose little fibers. Whereas a filament yarn, like in a nylon jacket, long filaments of indeterminate length, they would have to be damaged for them to be shed. They don't shed that easily. But all of these end up into a fabric, whether it's a knitted fabric, or a woven fabric, or a bonded fabric, and there's several different types. The most types that you encounter would be knitted fabrics and woven fabrics.
Is there a difference in the shedding properties of fabrics that are of the staple or filament type?
There is a difference. Yeah, staple fibers, staple yarns, and staple fabrics tend to shed more. And also they tend to hang on to things more.
They're tacky?
By their nature. Just the surface characteristics of the fabric are such. The more worn the fabric, for instance, you may wear away a lot of the loose fiber ends that are present. This particular fabric wouldn't hang on to things too well. Whereas a new fabric that has a lot of loose yarn still, on the fabric may hang onto something and keep the fibers longer. There's a bulky sweater. That bulky sweater will shed, and it picks up a lot of stuff just by its nature.
As opposed to the filament?
Well, filament fabrics, you may find a filament fabric that is a very slick fabric. A nylon jacket would be a good example. You may find filament fibers in lingerie. Any type of slick fabric that is made up of this particular type of yarn wouldn't shed very easily. It wouldn't hold on to things very easily. And something to consider when you're looking at evidence. You kind of expect to see certain things based on the fabric that you're handling.
You saw Nicole Brown's, the dress that she was worn on June the 12th, that she was found in. Did you examine that fabric, a known portion of that dress?
I did.
Could you tell us whether that was a staple or a filament type of fabric?
I don't recall on that. It may have been filament. I'm not sure on that, though.
Okay, we'll get back to that. All right, you indicated earlier that you can examine fibers, and you talked about the mounting. Is the mounting process for fibers the same as the mounting process for hairs? On slides, that is?
It's pretty much the same techniques, same mounting materials, precautions. Probably take a little more precaution with fibers because of their nature.
Their nature being?
Well, they're smaller, and you can lose them if you're not careful. They tend to float around a little bit more.
But other than that?
Same. Everything else is the same starting point.
And with respect to the examination process, how do you conduct a fiber exam?
Well, the exam is conducted in a similar way in the beginning as with hairs. That is, you look at it with a stereo microscope, look at it with a research microscope. You may compare it with a comparison microscope to see if the question material found on the victim's clothes looks like the fibers from the fabric of the suspect in the case. And then once the determination is made that they either look the same, or if they look the same, then you go to the next step. And there are several steps beyond that which help to confirm this eyeball association that you're making.
Well, let's assume for a moment that you have compared a question fiber from the crime scene, say a fiber on a victim's shirt, to clothing that the perpetrator was wearing when he was arrested. And let's say that you determine that they exhibit the same microscopic characteristics. Is that where you stop?
No, you go on. There are other confirming tests.
Are they the same with respect to whether the fibers are man-made or natural fibers?
No, they'll differ. Man-made fibers can use additional tests for confirming.
Okay, let's start with the natural fibers, naturally occurring ones. Let me just back up and ask you this. You said there are additional steps that can be taken or tests that can be done on man-made fibers?
There are.
So in other words, would it be fair to say that you can do a certain number of tests beyond the microscopic examination on man-made fibers and natural fibers, and then you can do more than that if they're man-made? You know what I mean?
Sustain.
It would be much better not to lead, because let me just ask you, if you have, whether the fibers are man-made or natural, after the microscopic comparison reveals the same or similar characteristics, what steps do you take with respect to man-made or natural?
Almost all of the steps beyond that point are still microscopic, but there are different instruments, different types of microscopes that can be used to confirm an identification of the fiber type and also to compare certain properties of the fiber. You might, as an example, a polarizing microscope might be the second step after a comparison is made. A polarizing microscope is one that is designed specifically to allow you to look at polarized light and how it affects the synthetic fiber that you're looking at. And a polarizing microscope it's not too simple, but it's simple to understand when you think in terms of sunglasses. If you have polarizing sunglasses, you know how when you wear them, they tend to cut the glare. They do this because they're designed to let light only enter your eye in one direction. That the light coming and scattering in all directions hits your eye. It's like Venetian blinds. It only lets the light come through in one direction. You put a polarizer on the light source of a microscope, and you can control which direction you let the light hit the fiber with. By placing another polarizer above it, which is called an analyzer, which is essentially the same thing, the polarizing filter, And by adjusting the orientation of these, you can actually cross them so that no light comes through. But when you insert that fiber in between, the fiber interferes with that light, and you'll see color. And it's called interference colors. And by examining the interference colors and by doing some measurements with other instruments that can be added to it, you can identify the generic group of the fibers, as is a nylon fiber or it's a polyester fiber. These can be done with that instrument. And you can compare. You can do comparisons of interference colors with question and known.
If, for example, you have man-made, natural fibers, after you do the microscopic comparison, the straight microscopic comparison, what would be the next thing that you might do to compare questioned and known natural fibers?
Well, once a determination is made, as an example of a, let's say, a cotton fiber, looks the same under the comparison microscope, next step would be to take it to what's called a microspectrophotometer. And it's a big word. I don't know if we have a picture of that.
We do. People's 467? 9. 469, Your Honor?
469.
Is that a microspectrophotometer?
It certainly is.
And tell us what it does.
Well, the microspectrophotometer it's like a regular microscope that has a photometer head. It has a reader that sits on the top of it. As an example here, you can see I'm looking through the microscope. Above that white area, just above it, is measuring the light that's passing through the fiber. And it can measure light at specific wavelengths. So that if the color that's added to the cotton fiber, it comes, let's say maybe 3 different colors are added to the fiber to give it the color that you see normally in daylight. That this instrument can show that these different components will interact with the light at specific wavelengths. And it'll present you with an absorption chart, which shows where the colors are and where they're absorbing. Our eyes see one color. The instrument actually allows you to see where these components are in the visible spectrum.
And the chart you're referring to, is that actually shown on the screen of the monitor in this photograph?
It's hard to see, but yes, that's the what you get from looking at the fiber.
Okay. Now we're showing you a chart. I'd ask that it be marked People's 469A, Your Honor.
469A.
Tell us what that is, sir.
Well, this chart here it shows you 2 brown carpet fibers that were examined under the same conditions. The chart that was prepared of one differs from the other. It's because they're different brown colors, just to show you when they don't look the same.
And is that an example of a chart that would be produced by the microspectrophotometer?
That is, yes.
Have you ever heard of the term a spectral fingerprint?
Well, I've heard that before, yes. It's essentially the spectral fingerprint or representation of the colors that go into the fiber, the dye components.
So when they say spectral, they mean?
Well, to the color range that we're familiar with. Fingerprint in the sense that it identifies the components of a particular fiber by the color components.
Fingerprint, Your Honor.
Okay, could we go back to that second chart? Mr. Dietrich, what would you say about the results on this chart with respect to whether or not the blue cotton fibers match?
Use the word match.
Sustained.
Okay. With respect to whether or not, with respect to the results on this chart, can you tell us whether or not you would draw the conclusion based on these results that these fibers had the same origin?
The chart that you see indicates that the colors are different. That in fact, the one fiber If if the question is, did the one fiber come from the same source based on this spectral result? They did not.
And you were looking then at the actual wave pattern, is that correct?
You look at the absorption peaks, absorption and transmission of that particular color in specific wavelengths.
Okay, and that second one, can it be marked 469B, Your Honor?
Yes.
The blue cotton. What's that? Technical difficulty.
Anybody want to stand up and take a stretch while we're at this point? Well, I'm going to stand and take a stretch. Be my guess. All right, Mr. Fairlow, you got what you need? All right.
This chart be marked 469C, Your Honor.
Yes.
All right. Is this another chart that would be generated by the microspectrophotometer?
Yes, it is.
Okay. Can you tell us, with respect to the results depicted in this chart, whether or not you would conclude that the two fibers measured by that instrument would be determined to have had the same origin?
Well, I don't know if I'd use the term measured, but yes.
Whatever term you like.
All right. When one fiber was tested, it produced a curve, like you see, let's say the top curve. The second fiber produced the bottom curve. And what an examiner looks for is to see if there's conformity at the specific absorption peaks and transmission peaks. In this particular case, they do conform. This particular test was taken from the same fabric, which shows you another thing, that they don't have to lay one right on top of the other. That they will absorb dye differently. So you have to look at how the curves appear, not if they lay on top one another.
Okay, so in this case, the two blue fibers, they were actually picked off from the same material.
Actually came off the same yarn.
We have
So the fact
many
that-
yarn experts.
I'm sorry, Your Honor?
We have many yarn experts.
Yeah, that's right. And if we measured their yarn, it would, and you would try to follow the same peaks and valleys, and that's how you would determine whether or not it had the same origin.
Same peaks and valley comparison, yes.
Is there anything that will produce a different peak and any kind of additive? For example, if a piece of yarn, if you have two pieces of yarn from the same ball, same origin, one piece has a little bit of blood on it, the other one doesn't. Is that going to cause some difference in the result on a chart like this?
It will. It'll pick up the color, just not knowing any different. It'll absorb in that particular region of the spectrum.
Is there any way to account for that in determining whether or not two fibers could have had the same origin, so that you don't improperly exclude it because of the blood?
Well, you could test a test sample of the fabric and add blood to it to see the effect of blood to that particular known sample. Or you could clean off the blood and see it without the blood present. Blood peaks. The blood peak is pretty easy to see, and once you see it with the microspectrophotometer on the chart, you can infer that.
Is that a pretty common issue in criminal cases?
Well, in criminal cases often involve bloodshed, and clothing fibers often pick up blood. The question fibers that you look at may have blood on them. The known standards that are taken routinely are not, you don't try to take known standards from the bloody area. Try to take it from a clean area, but you may have to take it from the bloody area just to show the comparison. But we're talking a real small piece of fiber, though, and the blood, and you're talking about a very small area of the fiber that you're actually testing. But you can pick up an absorption in that particular, if it has blood on it.
All right, so let's assume for a moment that in your comparison of the natural fibers, you've done the comparison on the comparison scope, and they seem to have the same characteristics. You go to the microspectrophotometer, and you produce wavelengths that have the same characteristics, peaks and valleys. Is there some further step you can take?
Yes, there is.
And what is that?
Fluorescence. Fluorescence microscopy can be used.
You want to mark this
470?
469?
470, Your Honor?
470?
Yes, thank you, Your Honor. What, this is the fluorescent microscope?
Yes, it is. It's, again, a comparison microscope which has fluorescent cubes in the uppermost portion of it, and they can be altered. A specific type of light is reflected off of the surface of the fiber, and if the fiber has fluorescent qualities, that is, it will absorb certain wavelengths and also emit a longer wavelength, it may appear to be a different color to the eye under different lighting conditions. We use ultraviolet light, blue light, and green light. And comparison is made between the question and known the same way. If the question fiber and the known fiber fluoresce the same, and they are the same in all the other tests that are conducted, it's just another confirmation. Where you might have problems with it, you go through the steps and you find that they are all very similar, but the fluorescence is wrong. And that might be a way to eliminate that fiber as possibly coming from a particular garment.
Okay, so if you're trying to determine whether or not a question fiber and a known fiber could have had the same origin, when you subject them to, say, did you say green light, for example, you might use?
Yeah, a green light.
A green light under the fluorescent microscope, they should fluoresce the same way?
They should, right, if they fluoresce, they should fluoresce the same. The color that you're looking at visually should be the same.
And if it doesn't,
It may
then...
not fluoresce. I mean, some fibers just don't fluoresce at any wavelength.
Okay, but if one does, if the question fiber fluoresces under the green light
Right.
and the known fiber does not fluoresce under the green light, what conclusion, if any, would you draw?
Well, there's two possible. One, that they came from different fabrics, and two, something happened to the one that the other, it didn't happen to the, for instance, you may have some time factor. You may have the fiber laying out in the sunlight for a long time and losing its fluorescent qualities, their ability. It gets faded. It leaches out whatever ability that fiber had to fluoresce. The known fabric was retained and wasn't affected the same way. You might find that the question fiber doesn't fluoresce, yet the known fabric still does. So then it's a matter of maybe doing some tests, taking some of the known fibers, letting them out in the sun for a while, same period of time, and then seeing if they act the same way.
So would you ever call an exclusion, that is, determine that a question fiber and known fiber could not have had the same source based solely on what you see under the fluorescent microscope?
You could. It depends on the circumstances, the historical information that might be available about a fabric. I've done it before.
Now, so far, the steps that we've gone through, are these steps that you can do for both man-made and natural fibers?
Yes.
After the fluorescent microscope stage, is there some further step that you could take natural fibers?
With synthetic fibers?
No, natural fibers. Can you go any farther in your analysis?
Oh,
than this
there's
with
other
natural?
tests you could use. Sure, you could strip the dye using thin layer chromatography and do a dye separation. There's a number of other tests that could be used.
Are they routinely used?
Well, in some laboratories they are. We don't use thin layer chromatography routinely in our lab. It's a destructive technique. In some instances we might. use it depending on the circumstances. You have to have a lot of known standard to work with. That is enough so you can determine the system that you might want to use, because you have to take the dye out of the fiber, and then you have to see how it can separate on a chromatographic plate. So you need enough to work with to experiment, to see if you only have one fiber found on the victim's clothes, but you have a lot of fibers from the suspect. You want to make sure that if you're going to do anything to this question fiber, that you better know the results you might expect to get. Because once you take the dye out of the fiber, you've destroyed it.
Okay, that's thin layer chromatography.
Right.
Now, the processes that you've outlined for us so far, are any of these destructive processes?
The ones that we use are not destructive.
So that when you complete all of the steps that you use at the FBI, is the hair or fiber intact as you found it?
Yes, it is.
All right, now for man-made fibers, can you go farther than fluorescent microscope and thin layer chromatography?
Yes, you can use FTIR, infrared spectroscopy.
People's 471, Your Honor?
471.
So after all the steps you've gone through, everything looks the same, and you come to FTIR. What does that stand for?
Well, I'll probably really murder this one, but it's a Fourier transform infrared spectroscopy. Fourier is spelled like F-O-U-R-I-E-R. I apologize.
Transfer?
I apologize to these people who know more about it.
We'll say FTIR.
FTIR is beautiful.
Okay, what does it do?
Well, the instrument that we have has a microscope attachment. A small portion of the fiber is flattened. It's actually a roller is applied to it to make a thin layer of the fiber, and then passing infrared light through it, it will again absorb and it will affect. It will affect based on the polymer that's in that particular fiber. The molecules that make up the fiber interact with the infrared light. They start shaking and vibrating in all directions, and this shaking and vibrating allows a chart to be prepared. And this chart will identify the polymer and also can be useful for a comparison.
Okay, let's pull up the chart and tell us how it can be useful for a comparison as well as the identification of a polymer. Actually, before we do all that, what's a polymer?
A polymer, could be a man-made fiber, as an example. It's a long chain synthetic material, man-made material, made up of a lot of smaller components. Could be called monomers, and a lot of them are poly, so it's a polymer. You might start with some small building block, and you make a lot of it, a long chain of it. And that's what makes up a particular fiber. Different building blocks make up different materials.
Okay.
A nylon material is different than a polyester material.
So when you say identification of the polymer, you're telling us that when you identify the polymer, you're identifying whether the man-made fiber is rayon or nylon, that sort of thing?
Or nylon 6 or nylon 6/6 or nylon 11. Depends on the type. There are different types of nylons, and there's different types of acrylics, and there's different types of polyesters. And this instrument can be a little bit more specific. Whereas I can say it appears to be a nylon fiber based on my test, this could tell me it's a nylon 6/6 fiber.
So then, after the molecules are all shaken up, a chart is produced,
A chart is produced.
which measures what?
Well, then again, you're kind of going into the field of FTIR that perhaps I'm not most expert at. But it gives a chart of the reaction of the infrared light through that material.
Your Honor, may this chart be marked People's 471A?
471A.
And is this an example of a chart that would be produced by the FTIR?
Yes, it is.
Tell us what it shows.
Well, this particular chart is indicative of a nylon 6/6 chart. And that's based upon a comparison with a database of spectra of nylons. by comparing that spectra that's produced with known standards, that particular polymer can be identified. It's useful also from the standpoint of comparison, because dye components, coloration, anything that's added to the fiber will also interact with the infrared radiation that's hitting the particular fiber. So that you may have dye peaks that may not be characteristic of an undyed fiber. So it can be useful for comparison as well, besides identification.
In which case you would be comparing the different peaks for each fiber?
The position, yes, the position of the peaks in relationship to each other. Question and known.
Now this just reflects one fiber's measurement?
One fiber.
I think you spoke earlier about the cross-section of a fiber on one of the charts. Is that something that you routinely compare, the cross-sections of fibers?
Yes, it's a very excellent way of comparing fibers.
And what is a cross-section of a fiber?
Well, a cross-section is how it looks if you look down the end of it. Like if you lopped off a tree, you know it's round. Well, you lop off a fiber, you know what shape it is.
Yeah, can you always see the cross-section of a fiber without cutting it?
Sometimes you can. Sometimes you can. The more intricate the cross-section or the more unusual the cross-section may require using a sectioning technique that it's a manual technique, which you can do right in the unit. Or you might take it to the scanning electron microscope, and there's a technique that can be used there which will allow a different type of section and a different type of look.
Okay, on the chart concerning fibers that we saw before, you pointed out the trilobal look and then the one that had the 4 holes in it like a die, like dice.
Right.
Okay. Were those examples of cross-sections?
Those were examples of cross-sections, yes.
Okay. Now, what is the scanning electron microscope that you said could be used in connection with the examination of cross-sections?
Well, the scanning electron microscope actually passes a beam of electrons striking the surface of a material, and then it is detected. The material, the reflection of those electrons onto a detector will give you an image, a three-dimensional image of what you're looking at.
And did you furnish some photographs to be shown to the jury of an example of the kind of photographs that are taken by the scanning electron microscope?
I did.
People's 472, Your Honor.
472.
Tell us what this is, sir.
This is a nylon fiber.
Your Honor, may we approach?
Yes. don't you take it till 5 minutes till, because there's one other thing I need to discuss with you before we let the jury go. Proceed.
Okay. Well, this was 472. Please tell us what this is.
It's a regular trilobal fiber.
What does that mean?
Well, the 3 lobes of the fiber are uniform as in length and appearance.
Meaning that no one curve is longer or different than the other two?
Well, that's what that means, yes.
And is that a photograph taken from the scanning electron microscope?
It is, yes.
And what does this fiber come from?
Sustain. Sustain. Just what type of fiber is it?
What type of fiber is this?
It's a nylon automotive fiber.
Proceed.
Okay. Next. What's that? May I make this, sorry, Your Honor, 473?
473.
This is a nylon automotive fiber of a different cross-section.
Okay, this is a different, this looks different. How's it,
Well, it's different from the standpoint of appearance. That is, I call it the jack cross-section. It has, if you had toys as a child, some of you may not be old enough, but jacks had the little knobby ends on them with a little ball in your jacks. Well, anyway, I call it the jack cross-section. But it has 3 lobes, little knobs on the end of them, and it's a little bit unusual. It's different. It's, again, another automotive fiber.
what's that?
Well, it's called the Michelin Man. I didn't label this one, but it's the same, essentially the same fiber as the previous one, as 2 components made by the same company, but they changed the cross-section of it, and it appears differently. This, again, is another automotive nylon fiber made by the same company.
People's 474, Your Honor.
So, Mark.
Okay, so were all 3 of these, 472, 473, and 474, scanning electron microscope pictures?
They were.
And all of them were taken of a nylon carpet fiber from an automobile?
They were.
And by the same manufacturer?
All by the same manufacturer.
We'll let this
Were they taken from different years?
sustain. Sustain.
All right, after all the tests are conducted with respect to comparison microscope, microspectrophotometer, fluorescent microscope, polarizing light, scanning electron microscope, FTIR, have I missed any?
I think you have them.
After all of that, what conclusions can be reached concerning the comparison of fibers?
Well, after all that, I can only say that the fiber could have originated from that fabric.
Could have?
Could have.
And when you draw that conclusion, what has to be similar? To what degree do you have to find similarity? Can you have any differences at all to reach that conclusion?
Can't be any significant differences. Anything that you can't account for have to be all pretty much the same right down the line. All the tests, the original test and the confirming test, have to agree.
When you say no differences you can't account for, what does that mean?
Well, as I said, and you may have run some tests initially that there may be something that comes up in the subsequent tests that you can't explain. You may need to get some information about the historical information about the fiber or the fabric or what happened to the suspect's clothes before they got the clothes. As an example, As an example, the suspect goes home, washes his clothes, uses an optical brightener, fab with borax or something, I don't know, but whatever. And the police get the clothing, and they think that that's the clothing that he wore. The reaction of that particular fiber will be different using fluorescence, for instance. It may fluoresce, whereas the other fiber didn't. So you may have to do a test. You may have to get information. What happened to the clothes afterwards? Can we recreate the same situation? You might not be able to. It just depends. But for the most part, they'll conform all the way down the line when an association is made.
So you can't say that,
Stricken, Your Honor.
Yes. That's to be stricken and disregarded.
I didn't hear.
Stricken and disregarded, the word match.
Oh, I didn't hear.
Not in this context.
Yeah. So you cannot say that a particular fiber definitely came from this one piece of fabric and no other.
Oh, no.
You can't say that. Okay, but if you find that the fiber does exhibit the same characteristics, a question fiber, as a known sample of cloth, what is the likelihood of finding another fabric at random that has fibers exactly like those of the question fiber?
Objection.
Sustained foundation.
Okay, let me back up. What is the significance of a conclusion that a question fiber could have come from a given known sample of cloth or item of clothing?
There is a great deal of significance to certain fiber associations. Some are more common than others. That when you take, for instance, a man-made fiber of a particular type and you color it, you add color to it, it takes on a sort of a uniqueness. Now, it's a fact that the manufacturer is not going to make...
Excuse me, Your Honor. I object to sort of uniqueness. There are no degrees of unique, and unique would be
Sustained.
improper.
Speaking objection,
this?
counsel.
All right.
All right, I think we're going to quit at this point, though. All right, ladies and gentlemen, we're going to take a recess at this point. Hold on, don't go away. Let me see Mrs. Clark and Mr. Cochran with court. if you can step down. Your order to turn tomorrow morning at 9 o'clock. All right, ladies and gentlemen, before I let you go and give you the standard admonition, one other different matter. Earlier this week, it was brought to my attention that there was a certain book that a couple of you were reading, and some concerns were expressed to me about the content of that book, which is why I asked the bailiffs to collect that in an abundance of caution. But I've thought about it, and that book is clearly a work of fiction, and you have promised me that you will decide this case based solely upon the evidence that is presented here in court, and only upon and using the law as I instruct you, and I'll return these books to you. I apologize to you for the inconvenience, but I'd hate to have this case have something horrible happen for reasons that have nothing to do with the facts and the evidence. I'm sure you understand, and I'm sure you will follow my instructions to reach your verdict on this case solely on the facts, the law, and the evidence. All right? Remember all my other admonitions to you, however. Don't discuss this case amongst yourselves. Don't form any opinions about the case. Don't allow anybody to communicate with you. Don't conduct any deliberations till the matter has been submitted to you. We'll see you tomorrow morning at 9 o'clock. All right? As far as the jury is concerned, we'll stand in recess and we'll reconvene in 15 minutes. All right, back on the record in the Simpson matter. All parties are again present. The jury is not present. Counsel, let me just get rid of a few easy issues first. With regards to the use of the two photographs, there is apparently a first booking photograph of Mr. Simpson, which just does show him in a more benign attitude than what appears to be the, for lack of a better word, a more sinister visage. But the one that they've chosen to use, which they're entitled to do, I mean, it's their exhibit board, they're entitled to make it the way they want to. But they do so at their peril, since I'm sure that'll be part of the argument. All right, as to... Yes, you may. Mrs. Robertson. All right, I was a little concerned. The reason we stopped 2 or 3 minutes early is I was a little concerned where we were going with those electron microscope photographs in light of the court's ruling with regards to the report. Ms. Clark, do you want to let me know where we were going with that?
We had just about, that was about it. I think I had one last question. I was not going to elicit the fact that this was a Bronco carpet or the manufacturer manufactures Bronco carpets, because I think I'm pretty clear on that. I was simply going to ask if that was representative of different years, that the manufacturer changed the carpet type in different years. That's it. As far as that was going, then I believe the last objection, I didn't think that that would be objectionable. That's why the court probably saw me give a quizzical look. I didn't intend to go any farther than to indicate that the manufacturer did change over a period of years, and it's illustrative in nature, nothing more. And I thought that would be acceptable and within the parameters of the court's ruling.
Well, I thought it was illustrative of different types of fibers as they appear in electron microscope photography. Mm-hmm. And I thought that was about the extent of it, so I think you've covered it at this point.
Right, and I won't go back to that.
All right.
The question I think that elicited, or the answer that elicited the last objection, I don't understand counsel's objection. This is an expert. Perhaps I should lay some further foundation with respect to the number of fiber comparisons he has done, but I think I already have elicited the fact that he's done 500,000 comparisons in his 17 years, and some of, roughly half or some of those were, they were both hair and
refresh my
fiber.
recollection as to which one we're talking about.
What question?
Yes.
I asked, after an objection by counsel, what is the significance of a conclusion that a questioned fiber couldn't come from a given known sample of cloth or item of clothing? Objection overruled. And then this is what the objection was focused on is the following answer. There's a great deal of significance to certain fiber associations. Some are more common than others. Then when you take, for instance, a man-made fiber of a particular type and you color it, add color to it, it takes on sort of a uniqueness. Now, it is a fact that the manufacturer is going to make, and then there was an objection to the use of the term uniqueness.
Where are we
This is a
going?
witness-
Where are we going with this?
Just fibers. We're not talking about Bronco fibers. We're talking about in general the fact that, you know, all red fibers are not created equal. All black fibers are not created equal. And this witness has seen enough of those fibers to know. But we're just talking about fiber comparisons, Your Honor.
Please, the court, I think this witness is obviously much too intelligent to misuse the word unique accidentally. There is no such thing as sort of unique, pretty unique, or more unique. You're either unique or you're not. And if you're unique, you're in the match category, and I think that we ought to have some pretty firm rules about that. I mean, I see everybody walking right up to the line, automotive carpet fibers, years they were made. I thought these were the things that were not going to be mentioned. These were
Which is
mere
why-
examples.
Yes, mere examples. All right. Ms. Clark, as to the, he can testify to how differentiation is made between fibers, which includes colors, dyes, other examples of how one goes about talking to manufacturers and finding out from databases, that sort of thing. That goes to the technique. I don't know if you really want to do that since you're not going to be able to offer that.
Well, there's other fiber matches besides Bronco, Your Honor.
Well, I understand. See, but you fall into that. There are others that appear to be similar.
I'm sorry. Right.
Right.
But, well then,
No, I understand that.
okay. The other question I have is this. I understand the court's ruling with respect to not using any of the information in his testimony concerning the report from Maslin, but the witness is permitted to testify to his conclusion that was turned over to counsel, that he found, that he identified, he found the same microscopic characteristics in the Bronco fiber from the defendant's car as he did from the carpet fibers found on the Rockingham glove and knit cap.
That's correct.
Okay. And if the defense then opens up this area and says, well, there were tons of carpet made, then he should be permitted to answer that question rather than lie to the jury.
Well, if they're so foolhardy as to do that, but I suspect that the cross-examination will be all you can really say is it looks similar, correct, but you can't absolutely say it came from this source, can you? No, I can't. Thank you very much. Goodbye.
Okay.
Your Honor is very specific.
I should also indicate...
Because the shorter the cross-examination is, that gives the message to the trier of fact that who cares?
I wonder if that message was received. But let me ask you this, Your Honor. With respect to this expert's
But
opinion...
what I'm doing by saying that, though, is I agree with you. There's a possibility that if we get into commonality and that sort of thing, if they get into that area, that's a different story.
Okay. Okay. Further, this witness, the reason he undertook the further inquiry to Maslin is that he found something unusual about those carpet fibers. And then, based on what he saw in them, in his experience, has nothing to do with Maslin. This is before that ever happened. In his experience, he looked at them and he thought, this is unusual. He then looked for he looked through other items and found the match to other items in this case. And based on that, went to Maslin. Everything up to the point of going to Maslin, as I understand it, is within the range of his admissible testimony.
Is it in his report?
Yes, all of those matches are in his report. All of those,
The report that was turned over to the defense?
correct.
All right. Mr. Blazer? I'm sorry, Mr. Bailey, who's going to address this?
Maybe at the second.
Sure.
Well, Your Honor, the reports that I read prior to yesterday's revelation had nothing to do with randomness, rareness, or anything else. They simply said it was similar, as you have correctly figured out. Second, we have a real problem here. Mr. Diedrich has a virus called Match, and he's infected Miss Clark, and that word keeps cropping up. And I don't know how you're going to enforce it, unless you get a little bit tough. I ask that you do that.
Let me respond to that, though, Your Honor. I have spoken with the witness about the word match, and we're not going to do that anymore. We're just not. And I apologize to the court. We'll have a longer discussion about it. What we will do is I propose to ask the witness a series of questions so we can both practice using the words same microscopic characteristics and other terminology that the court will find acceptable. With respect to the unusual features of the carpet fiber, this is no different than the hair comparisons. This all goes to the same general body of information that all hair and fiber examiners have, which is, in order to compare hairs, they have to have unusual or distinctive characteristics, or else you can't compare them. They're not suitable.
I understand that.
Okay, and that's the same thing with fibers.
I understand it.
Okay, so we don't have
But
any...
to say I compared the question fibers amongst themselves with the known fiber from the Bronco that we have, that's one comparison.
Right.
But then comparing it to other things, that's something different, which we don't have involved here.
You mean other years of Broncos? Is that what you're talking about? No, we won't do that. Okay. All right, I understand. Thank you.
You know, I may be heard on a discovery request.
Yes.
I'm extremely concerned about where this is all going. When I had my conversation with Mr. Diedrich yesterday about the carpet fiber, and he didn't show me his report, it wasn't provided until you ordered it, I asked him whether he had done any similar research about blue-black cotton fibers, and he says, well, he just does that kind of as a general, for all of his cases, in a general way. And so I asked him if he could give me copies of what he had, of what he could accumulate. He said, it'll cost you $85. I said, I've got $85. I want that material because I think he's done other research. I think there's a large amount of other material that we have not gotten that they intend to try and get into.
My recollection of that conversation, as if you recollect, you all were using my photocopy machine to make copies of this stuff. I took that as a jocular comment by Mr. Diedrich that he ought to charge $85 for the services of photocopying.
Well, if he,
That's the way I understood it.
This happened before you came out and ordered the material. This had nothing to do with
All
that.
right, is there any other similar report regarding blue-black cotton fiber?
Sir,
Okay.
it's the only research I did on this case.
All right, thank you. Okay, anything else with regards to carpets and fibers and hairs?
Before you hear from Mr. Ullman and Mr. Goldberg, there is the issue of the defense witness list. Now, we are probably a day from finishing with Mr. Diedrich, or a day and a half in terms of testimony.
You think so?
Yeah, I think so. I think you've suggested the appropriate cross-examination in this case, and I'm sure they'll take your advice.
You know, we ought to go to the Talmudic courts where the judge does all the questioning.
Then we'd have to object to that. And it could take 6 months.
Not in this court. All right, go ahead.
At any event, I think we have a right at this point to know what the witness lineup is going to be for the defense.
They will, I think it was agreed, Your Honor, that, and we talked about this, they'll get a list. And first of all, I think they're being optimistic with regard to when they're going to finish. Ms. Clark has previously indicated she would take a minimum of 2 days for direct. That's what she told us herself. And there'll be cross-examination. And what we agreed was that as soon as they finish their case, we'll give them the list. And I think you agreed that was appropriate. We'll give them a list, and we'll give them more time than what they've given us. We're not going to just hold back and give a witness at a time. I want to give them enough so they can keep busy, because we're going to move this case along, Your Honor.
All right, my only concern, though, is Mr. Cochran, is you know what the prosecution case is. We're going to finish with Mr. Diedrich. My guess is Wednesday or Thursday.
Right?
And the next witness for the prosecution will be Juditha Brown, which my guess will be a 20-minute witness.
Should be.
And that'll be a wrap. Then we will have to go into perhaps a day of the people moving their various evidence into evidence. And I anticipate, however, I only anticipate between 12 and 20 objections to pieces of evidence, because I think everything else was pretty much agreed to previously. So we should be able to do that in half a day. And then we will get to the defense case probably Thursday afternoon or Friday. So
we previously indicated, we'll be ready to give them a list as soon as they rest. Your Honor, the problem has been with this prosecution team is that as soon as if they see something on our list, they very well may not rest, and that was the issue you were prepared for.
No, they've told me that they told me they're going to rest after Mrs. Brown.
That was a representation, and we think that that'll be the case. Of course, there are probably a few stipulations we may need to enter into in terms of some of the exhibits, but I don't think there'll be any need to call any additional witnesses beyond what we've indicated already. At any event, the rule or the deal has been 3 days, and, you know.
Right. I agree with you that by tomorrow we may hit the 3 days.
Well, unfortunately, I won't be here tomorrow, as the court is aware. May I give the list on Wednesday morning upon our return? And I'll make sure they have it Wednesday morning. Your Honor, there's going to be, by the time they finish this case, trust me, it'll be probably more like Friday before we can start, but they'll have enough time, Your Honor.
Wednesday morning.
Wednesday morning? Thank you,
Wednesday
Your Honor.
morning. 9 o'clock.
Oh, what time, by the way, someone will be here.
Oh, I'm
tomorrow.
sorry, Wednesday
Are we starting
morning.
Wednesday at what time?
Yes, I know.
We're going to start a little,
Mr. Darden, we're not going to finish Mr. Diedrich tomorrow.
we're going to start a little bit, I don't think so.
And if you recollect, we agreed on Wednesday we would start at 10:30.
So Wednesday at 10:30. Thank you.
All right, and so that gets us to Thursday and Friday.
May I inquire, Ms. Clark, I don't know whether there's any possibility she'll finish in the morning?
I'd like to say yes, but I really doubt it.
Mr. Bailey, there are just too many of these hairs, and
I understand. I simply want an understanding that if she does finish, I'd like the weekend to go through all these exhibits, which we just saw yesterday with my expert in detail, before having to start. Thank you.
okay, let's move on to the motion. There is a motion to strike, actually, a renewed motion to strike with regards to the foundation for the blood evidence, which I think is the appropriate characterization of where we are at this point.
I believe that's an accurate characterization, Your Honor. Actually, this motion really renews a prior objection to the admission of comparative evidence using the reference sample of Mr. Simpson's blood sample prior to the appropriate laying of a foundation for the admission of that blood sample. And I believe Your Honor's ruling at the time was that you were not going to dictate to the prosecution the order of their proof, that we could proceed subject to the laying of a foundation. Our motion at this point calls to the court's attention that there is no foundation in this record for the admission of a reference sample of Mr. Simpson's blood. And therefore, unless the prosecution is going to offer some additional evidence to lay that foundation, all of the DNA comparisons and all of the conventional serology comparisons comparing the reference sample of the alleged reference sample of Mr. Simpson's blood must be excluded from evidence. Now, the prosecution has filed with the court a trial brief number 7, in which they assert that there is no need to call the nurse who actually drew the blood from Mr. Simpson in order to...
Mr. Allman, forgive me for interrupting you. Do we have People's 183 available? All right, may I have that, please?
I believe what we have available is a photo of People's 183. The actual exhibit itself has never been produced or offered in evidence other than a photograph. Certainly, calling the nurse would be the most obvious and direct way to lay this foundation, and there is at this point no explanation for the failure to call the nurse. The closest thing to an explanation comes in an argument contained in this brief that somehow the defense should be precluded from inquiring of the nurse as to how much blood was drawn at the time of the actual taking of the sample. But the problem, of course, is that what is represented in this brief misrepresents the testimony of the nurse. It's asserted here that the defense will never be able to establish a sufficient foundation for Nurse Paratus to testify to the amount of blood drawn from the defendant. The reason is that Nurse Paratus will testify that he has virtually no experience measuring the amount of blood drawn from a person and put in a reference vial. Moreover, he did not measure the amount of blood drawn in this case. His prior testimony as to the amount of blood drawn was a complete guess, lacking any foundation whatever. And that is simply not an accurate characterization of Nurse Paratus's testimony at the preliminary hearing. The testimony at the preliminary hearing proceeded as follows.
Counsel, can you give me the page on that?
Yes, this is page 25 of the preliminary proceedings on Thursday, July 7th, 1994.
Thank you.
Cross-examination by Mr. Shapiro. Question: how much blood did you withdraw from Mr. Simpson? Answer: approximately 8 cc's. Question: when you say approximately, you did not measure the amount? Answer: well, it could have been 7.9 or it could have been 8.1. I just looked at the syringe and it looked at about 8 cc's. I withdrew the needle from his arm. Question: nobody asked you to take a precise amount of blood? Answer: no. Question: and you did not record the amount of blood you took? Answer: no. It's just routinely, that's about the amount I usually draw. Question: and you do this on a routine basis every day? You do this every day in the jail, take blood? Answer: whenever, not for this sort of thing, it's usually for alcohol, blood alcohol. Question: but you do take blood on a regular basis? Answer: yes. So it's quite clear from the prior testimony that the nurse looked at the syringe and gave a very precise range, that what he drew was from 7.9 to 8.1 cc's. We believe that the testimony of this nurse is essential to lay the foundation necessary for the people to prove, as they must, that the reference sample to which they are comparing all of the unknown blood exemplars for DNA analysis and conventional serology analysis is actually the blood of Mr. Simpson. That is not established in the record at this trial thus far by the testimony of Detective Van Adder. Detective Van Adder simply testified that he was present when the nurse drew the blood, and then he was later given a vial, a purple-topped vial, which he put into an envelope and transported back to the Rockingham scene. And there is an essential gap in that testimony. Detective Van Adder did not testify that he observed the transfer of the blood from the syringe into the purple-topped vial. Nor can we simply infer that what he was given was the same blood that was drawn in the syringe, or fill that gap simply by speculation, because any inference to that effect is rebutted by the affidavit itself that the nurse allegedly filled out at the time this transfer took place. Now, Your Honor will observe the language of that affidavit certifies that, and I'll read it, I, Thano Paratus, collected a blood sample from the right arm of the above-named subject on June 13th, 1994 at 14:30 by venipuncture using a sterile dry hypodermic needle on a needle or syringe, and using the disinfectant is identified.
Aqueous citron, I think.
Right. I deposited the sample into an evacuated, clean, dry vial, which vial I received from Van Adder, and after initialing a label on the vial, I returned the vial containing the blood sample to the above officer. I declare under penalty of perjury that the foregoing is true and that this declaration was executed on May 19th, 1994. Now, there's a real problem here, of course, because the date that appears on that affidavit under the evidence code must be presumed to be a true date. That is, the court, in the absence of any absence to the contrary, must presume under evidence code section 640 that a writing is truly dated. That means that on this state of the record, that affidavit was completed on May 19th, nearly a month before the alleged operation that he was describing and verifying allegedly took place. If we follow the evidence code, the certificate is on its face presumed to be a fraudulent certificate. And in the face of the existence of that fraudulent certificate, we certainly cannot infer that all of the proper procedures were followed in this case. Obviously, there were some mistakes made, and those mistakes have to be explained before Your Honor can simply infer that the proper procedure was followed and that what we have in this case is actually the blood that was drawn by that syringe from Mr. Simpson. So we don't have a foundation in the testimony of Detective Van Adder, nor do we have a foundation in this affidavit or certificate itself. The people have made the argument in their trial brief that the California Evidence Code permits the court to utilize this certificate as a business record, so that through hearsay contained in the certificate, we can lay the foundation. There are two problems with that, actually three problems. The first problem, of course, is that the certificate is presumptively fraudulent. The second problem is that no foundation was ever laid to establish that this certificate is, in fact, a business record. No person in the course of this trial has gotten on the witness stand and testified that this certificate was made in the regular course of business, that it was made at or near the time of the act or condition or event, that the custodian or other qualified witness testifies to its identity and the mode of its preparation, and the sources of information and method and time of preparation were such as to indicate its trustworthiness. Those are foundational requirements required for any exhibit to be admitted as a business record. We don't have any testimony to establish that. All we have is a photograph produced through another witness who was not even present when this certificate was made, saying that when the blood was brought to the laboratory, this certificate accompanied it. And that does not supply the necessary foundation to establish that this certificate is indeed a business record or an official record. The third problem with this is that there is no legal authority in California to allow the identity of the donor of a sample to be tested in a laboratory to be established by hearsay evidence through the use of a business record or an official record. The only legal authority presented by the prosecution is the case of County of Sonoma versus Grant W. And if Your Honor will look at that case, you will discover that the identity of the donor was stipulated in that case. So the purpose of offering a hearsay record in that case was not to prove where the substance had come from. It was simply to prove the routine laboratory analysis of the substance. And that's very different from relying on a hearsay record to establish the identity of who the actual donor of the substance examined was. There are problems with the use of hearsay for this purpose. Number one, it deprives the defendant of the opportunity and right to cross-examine. And the answer to that is going to be, well, if you want to cross-examine, you can call him yourself. The evidence code gives us the right under Section 1203 to call to the witness stand and cross-examine the declarant of any hearsay statement. So certainly we have that right. But exercising that right, obviously, is going to come at a price. And the price that will be exacted in this case is that if we have to call the nurse ourselves to cross-examine him, we are put in the position of then bolstering the prosecution's case and supplying an essential element necessary to the proof of their case. And that is precisely the situation that was addressed by the United States Court of Appeals for the Ninth Circuit in the case that I supplied to Your Honor that was just decided last March. The case is Wigglesworth versus Oregon. And in that case, the court was confronted with an Oregon statute that permits a laboratory report with respect to the identity of a drug to be admitted without testimony by the technician who conducted the analysis, but gives the defendant then the right to call and cross-examine the technician. And the court noted that the dilemma this presents to the defendant to either forego cross-examination or risk bolstering the prosecution's case had been avoided in Oregon by an Oregon Supreme Court opinion that is also with the material supplied to the court, State versus Hancock, to say that in such a situation, then the cross-examination must occur during the state's case in chief. That is, the defendant must be given the opportunity to cross-examine during the state's case in chief before the hearsay report is admitted in evidence to supply the essential element. But since the Wigglesworth case had come before the trial court, before the Hancock decision had come down, and the defendant had not been given that opportunity, the court found that there was a violation of due process and granted a writ of habeas corpus. So I want to make it very clear that the objection of the defendant to supplying this essential element of the prosecution's case through hearsay is not only an objection based on grounds of the denial of the constitutional right of confrontation, but also a denial of due process in the sense of requiring the defendant, if he wishes to assert his opportunity to cross-examine, to himself risk supplying that missing element of the prosecution case. So to sum up, on the state of the record we have right now, at this point in the trial, and the people have indicated they do not intend to call Nurse Paratus, we are missing an essential gap with respect to the chain of custody of the blood that was drawn from Mr. Simpson's arm in terms of that actually being the blood that provided the reference samples. That gap cannot be filled by the testimony of Detective Van Adder, and in any event, it is rebutted by the existence of a certificate which is presumptively fraudulent, in which the nurse is certifying that the procedure under which this blood was drawn and placed in a vial certified on May 19th, 1994, a month before the procedure actually took place. So that discrepancy has to be explained before we can find the necessary foundation, and the only way to explain it is to call Nurse Paratus to the witness stand.
Thank you, counsel. Mr. Goldberg.
Good afternoon, Your Honor.
Good afternoon, Mr. Goldberg.
Your Honor, before I begin, I'd like to give the court a copy of some excerpts from the transcript that I typed up that I'd like to refer to, and it might be easier if the court had it.
I have them in front of me.
Uh,
I believe I have all the relevant.
You may or may not, and I
All right, well,
highlighted
sure.
certain things.
Sure.
I gave a copy to defense counsel.
All right.
Your Honor, I'd also inquire whether the court's copy of People's 183 for identification depicts the May 19th date, because on my photograph it was covered over by a piece of red tape.
It is covered over by a piece of red tape. However, the tape is semi-transparent, and it does appear to be a 5 to me, and I did look at it with a magnifying glass this afternoon.
Okay, because on my copies, I said I could not see that, although I don't think that's particularly important at any rate. I'd like to address counsel's argument and why it is that we have proven the chain of custody of the blood vial, and I'd like to divide it up into 3 points. First, I'd like to clarify what I regard to be, and what I also believe the defense has defined as the rather narrow issue that the court has to decide this afternoon. In other words, focus the court's attention on what really is the only issue before the court. Then I'd like to discuss the sufficiency of Detective Van Adder and Detective Lang's testimony in establishing the chain of custody. And then thirdly, I'd like to discuss the business records or official records exception to the hearsay rule. But the court need never reach that third issue because I think you can dispose this on the first and second issues. First, the people in the defense appear to agree, if you read the moving papers, that the law of the state of California is, with respect to a blood vial, a reference file, that the chain of custody of that reference file can be established by a police officer who says that they were present and saw it being drawn and then took custody of that reference file. The case that we cited for that proposition was People versus Lewis, and counsel also cited it. We both agree on how to interpret it. That's exactly what happened there, and I think we don't really need a case to tell us that, because we know that routinely that is how it is done in courts and probably in front of Your Honor, even in driving under the influence cases where the officer says, I was present, the blood sample was drawn, I took custody of it, and delivered it to the crime laboratory, and that is all that is needed in order to establish that the item is what it purports to be. Where we appear to disagree is we appear to disagree as to the sufficiency of Detective Lang and Van Adder's testimony in accomplishing that end. And to be even more precise in framing the issue, what the defense has said in their moving papers is they have said that the alleged gap in the chain of custody exists at a single link of the chain, so to speak, in the jail dispensary. They say that between the time that the blood left the defendant's arm and ended up in the possession of Detective Van Adder, there is a gap that prevents us from establishing chain of custody, according to cases such as People versus Lewis and ordinary principles of common sense. So it is that precise link in the chain, the point in time between the time that the blood left the defendant's arm, which Detective Van Adder saw and Detective Lang saw, and the time that they took physical possession of it, that the defense claims this gap exists where the prosecution has failed to prove chain of custody. That is the only issue before this court, and the only issue that the court is now being asked to decide and has to decide this afternoon. The other issues the court need never reach at all if it resolves that issue, as I'm confident the court will, in favor of the prosecution. Now, to take a look at the case law briefly before I get into the transcript, just to drive home the point that this really is the only issue. Not only do the people in the defense agree in our interpretation of People versus Lewis, but I think we also agree in our interpretation of the other cases cited by the defense, most notably American Mutual, which was a civil case in which the decedent died in a car accident and his heirs wanted to obtain money from an insurance company, and there was a defense that he was intoxicated. It was back in the days of contributory negligence. And the defense in that case wanted to show that he was intoxicated at the time. In that case, there was absolutely no evidence whatsoever, not a business record, not an official record, no precipient witness who saw the blood vial being drawn from the defendant. But there was a blood vial that was introduced that purported to be his blood. And all the court said there, quote, on page 497, "It is rudimentary that a specimen taken from a human body for the purposes of analysis must be identified before such specimen or any analysis made from it attains standing as evidence," unquote. Well, we don't need a case to tell us that. We know that from common sense. There has to be some evidence to say this blood came from this individual. That is all this case is saying, American Mutual. The other two cases, and I won't discuss them in any more detail, that counsel cited are McGowan and Madden, which both cited American Mutual, quoted the exact language that I just quoted to the court. Actually, it wasn't a quote, but they used the exact same language, stood for the exact same proposition, and in those three cases, there was zero evidence, not any evidence whatsoever, not a precipient witness, not an admissible business or official record, as to where this blood came from, and the court simply said, well, you have to have some evidence to show that it is what it purports to be. We have that evidence here, and the evidence is rather clear. Looking at the transcript testimony, Your Honor, and I wrote out what I regard to be some of the more relevant points. Under number 1 on my summary, we have testimony that Detective Van Adder and the defendant went to the jail dispensary, establishing personal knowledge. This is the part that counsel claims is lacking. We have Detective Van Adder asking the nurse to draw a blood sample for him, again establishing personal knowledge. We have him testifying, according to both the people and the defense, that he personally observed the blood sample being drawn from the defendant with a syringe, again establishing personal knowledge. And to quote under number 4 on my summary, "What did you do with the blood sample, if anything, after it was taken?" Answer, "I maintained custody of the blood sample and turned it over to the criminalist." It seems pretty unambiguous. He's standing there, he's watching this happen, he sees it taken, and the blood sample is then turned over to him, and he brings it to Mr. Fung. Next, under where I'm summarizing Van Adder's testimony on cross, and this is perhaps even more significant, Mr. Shapiro asked question, "Where was Detective Lang at the time you took O.J.'s blood sample from the nurse?" Answer, "He was with me." There's never been any doubt in this case as to whose blood sample that is, and that Detective Van Adder had personal knowledge of it. It is almost as if the defense now wants to somehow strike the question that was asked by Mr. Shapiro and the answer given as lacking foundation for personal knowledge. It was clear to Mr. Shapiro, as it was to everyone listening to this testimony, that these are events that he observed and witnessed that he has personal knowledge of. I won't read some of the remainder of the testimony that I've summarized over there, but I'd like to skip over to Detective Lang's testimony on direct examination, where he was asked question, "Were you present when the blood sample was taken from the defendant?" Answer, "Yes." Question, "And where did it go after that?" Answer, "It went into my partner's possession." And then later, "Okay, did you see it after the blood sample was drawn from the defendant and given to Detective Van Adder?" "Yes." "When did you see it?" "At the time it was withdrawn and turned over." It's very clear that they are there, that they are witnessing this, that he sees the blood drawn and he sees it turned over to Detective Van Adder. Now, what counsel is saying is that there's some sort of a gap. I don't see the gap. But what would this gap be? What happened? Did Detective Van Adder and Detective Lang suddenly become very squeamish, these two seasoned homicide detectives, and they fainted upon seeing the blood drawn from the defendant's arm? Nurse Paratus woke them up by slapping them after he had switched the blood vials and handed the blood vial to Detective Van Adder. So Detective Van Adder really doesn't know from his own personal knowledge that the vial came from the defendant's arm. Or did he ask Detective Van Adder and Lang, will you gentlemen please turn your back to us, close your eyes, and count to 10 for a few moments? And then he switched the blood vials and handed it to them. Or did he ask them to leave the room? I mean, we can't really think of a logical scenario under which they didn't have personal knowledge of these events. It's very clear that they were there, that these are things that they saw and witnessed, and that they're testifying to a continuous sequence of events. And if that did happen, when he asked Detective Lang, where did the vial go after the blood was drawn, Detective Lang would say, I don't know, because I was on the floor, I had just fainted. So this argument is clearly without merit, and the transcript testimony is absolutely 100% clear. But if there is an alleged ambiguity, Your Honor, then isn't that something that, of course, the jury ultimately has to decide? Because ultimately it is a jury issue. And let me just say on that score, this is not something that we're concerned about. Because if there really was this ambiguity that counsel's talking about, we'd want to do something to clarify, because we wouldn't want the case to go to the jury in a posture where a legitimate argument could be made by Mr. Cochran that we really don't know whether the reference sample came from the defendant or some other person that might have been present at the dispensary at that time who really committed this crime coincidentally. But Mr. Cochran is not going to make that argument. And if he does, of course, we'll be very happy. But he's not going to make that argument, not only because it can't be supported by the transcript, and it's not logical and doesn't involve common sense, not only because we all know that this is the defendant's blood. There are many issues the defense has raised in this case. They've talked about contamination, conspiracy, and whether things have been switched. But Mr. Cochran is not really going to stand before the jury and say, we really don't know if this reference sample came from the defendant or not, because it's not plausible. And because he really can't argue that. Because there's another way that we can prove chain of custody, or the identity of whose blood the reference sample is, that is given to us by the advent of DNA technology that wasn't available at the time that many of the cases that I've cited to the court and that counsel cited were written. And that is that we know that item number 12 and item number 14, concededly, both parties agree to this, are blood from the defendant. I'm talking about the dots of blood in the foyer, 12, and 14, the dot of blood in the bathroom. And remember, all we have to do here is to prove that the blood is what it purports to be, in other words, blood from the arm of the defendant. We know that those are the defendant's samples, not only because both parties seem to agree to that, but also because, as to item number 12, if I'm not mistaken, I'm sure the court will correct me if I am, we have a 5-probe match on DNA, DQ alpha, and also polymarkers. And although the court may not like the word match, that seems like a match. That seems like virtual identity, and I don't think Mr. Cochran's really going to argue to the contrary. And we know that that matches the reference vial. So we know circumstantially, even without Thonoprodis, even without Detective Van Adder or Lang, from the DNA evidence, that what is concededly blood of the defendant in his home matches the reference vial. So the reference vial really didn't come from the mystery person that was present in the dispensary and whose blood was substituted while Detective Van Adder and Lang were out cold on the floor. So if there is any alleged ambiguity, and we don't think there is, it's clearly a jury issue, and it's a jury issue that the people are not at all concerned about, and I don't think that Mr. Cochran is going to do a lot of arguing about when he has his opportunity to address the jury. Legally, he can. Tactically, he won't. I'd now like to discuss the business records exception, Your Honor, and the official records exception, although as I said to the court in trying to define the issues, the court does not have to address that issue at all. It's completely unnecessary, because as soon as the court concludes, yes, this is sufficient, this is enough evidence to go before a jury, you don't have to reach this. And what I would say is that chain of custody, of course, is a factual issue, not really a legal one. It simply involves common sense, trying to prove that something is what the proponent is saying it is. And the only difference between the decision that Your Honor is being asked to make this afternoon and the decision that the jury will be asked to make is that the standard of proof is different. Otherwise, everything else is the same. It's a common sense issue. It's a factual issue. The standard of proof for the jury could be beyond a reasonable doubt in their estimation if they find that this evidence is one of the circumstances that goes into a chain of circumstances upon which the people are relying to prove the guilt of the defendant. They would have to find beyond a reasonable doubt that the item is what we say it is, in other words, the defendant's blood, according to the circumstantial evidence instruction. But the standard of proof for Your Honor is merely whether there's enough evidence, in other words, a prima facie case, in order to be able to submit this factual dispute, if we can call it that, to the jury. And clearly, if the argument that it's not the defendant's blood is so poor that I don't think the defense will ever make it in front of the jury, I don't see why the court would accept it here, where the standard of proof that Your Honor is going to apply is significantly lower than the standard of proof that they will apply. But to get to the business records exception, I don't want to belabor the issue. I'll try to address it quickly, because as I said, I don't think the court needs to necessarily reach this. There are just a couple points I would like to make. First of all, what we are relying on to be more accurate in my terminology is not the business records exception, but the official records exception. And the only distinction between those two exceptions is that the official records exception does not require a custodian or other qualified witness to testify in order for the record to come in. Official records can be and usually are self-authenticating. And in the article that I appended to my points and authorities, I described how it is that a laboratory report, and we're not dealing with a laboratory report here, that's even a more complex issue, but how a laboratory report can come into court without ever having any witness testify in order to lay any foundation for that record under the official records exception. And Jefferson also talks about this in his treatise. And I won't go into all the elements of how that can be done. I laid it out. It was fairly succinct. It was on page 19 of the article that I read. And there are various inferences and presumptions that you apply in allowing an official record in without having an authenticating witness. The only one that I would like to specifically discuss, since the court, if the court feels it needs to, could simply look at that portion of my article. The only portion I would like to specifically discuss is the timeliness requirement, because it has been raised by counsel. That is the suggestion that here the evidence envelope contains the date of May the 19th. And what I would say there is that the case of People versus Utter, which we discussed and I also discussed in my article, says that one of the ways we can get an official record in without having a witness testify and prove the timeliness requirement that it was made at or near the time of the act, condition, or event described therein is that we have a presumption in the state of California, as counsel noted, that a record that contains a date is deemed to have been or is presumed to be truly dated. And when the record indicates that the date that the record was filled out is the same as the date that the analysis was performed, in People versus Utter, it was a chemical analysis, a laboratory report, that the timeliness requirement is satisfied simply by looking at the date on the evidence itself. In other words, if you have a date on an analyzed evidence report saying, I did this analysis on June the 13th, and the report is dated June the 13th, and you have evidence indicating that the test was on June the 13th, that in and of itself establishes the timeliness requirement without anyone testifying that it was made at or near the time of the act, condition, or event. Of course, here we can establish it because we know that the defendant was brought in on June the 13th at the time that's contained on this record. And we also know from Detective Van Adder that he received this envelope and that it obviously was filled out before he received it. So we can infer and presume the timeliness requirement from the face of the record itself. And the record is dated June the 13th as to the date that the blood was drawn. The May the 19th date is entirely irrelevant from a legal perspective, because if the court reads this, what I call the chain of custody statement, it is in the form of a declaration, the declaration saying, I declare under penalty of perjury that the foregoing is true, and that this declaration was executed on 5/1994. So the declaration is invalid, because it obviously couldn't have been executed on 5/1994. Presumably, Mr. Paradas filled out the declaration portion of this prior to the time that he actually drew the blood. But the declaration portion was never admissible, because we do not allow in declarations as any exception to the hearsay rule except in motions. But before a jury, the declaration itself isn't admissible. What makes this admissible is not that it's in the form of a declaration and executed under penalty of perjury. What makes it admissible is that it meets all the requirements of the official records exception to the hearsay rule. So if there was no declaration on it, if it didn't say this is under penalty of perjury, it would be equally admissible. And the fact that there is a declaration under penalty of perjury doesn't make it any more admissible. The fact that it's incorrectly dated doesn't make it any less admissible. It's simply irrelevant from a legal perspective. Moreover, this document has been published before the jury without objection, most notably in the testimony of Colin Yamauchi summarized under number 5 on my points and authorities, where Mr. Yamauchi is asked on cross-examination by the defense attorney, question, now let's move in on the bottom half from, quote, officers requesting withdrawal, unquote, down. Now, do you recognize this to be a picture of the envelope that contained Mr. Simpson's blood vial? Again, everyone understands that the testimony has established that this is Mr. Simpson's blood vial. And obviously they can't now object to their own question. We didn't object. Answer. It's kind of hard to read, but I recognize the name of the nurse that corresponds to the vial of blood and my notes. Question. And can you see now that this box we're focusing in on now refers to the affidavit of the person withdrawing blood? Answer. I can read that affidavit. Quote, a person withdrawing blood, unquote. Question. And it indicates that Thano Paradas, the nurse, gave the blood vial to Detective Van Adder. So here we have the defense again publishing this, and it had previously been published by the people, in front of the jury, reading the declaration, putting it up on the Elmo, and now they're saying that we're supposed to essentially unring that bell or strike that testimony, even though they elicited it, and unpublish this document. And on that score, I'd just like to bring to the court's attention the case of People versus Dorsey, which talks about the necessity of making specific and timely objections, and may also be of interest to the court later on in other issues that I'm sure the court is going to confront when it comes time to moving in exhibits.
All right, Mr. Goldberg, would you conclude your remarks?
This is the conclusion.
You're at 20 minutes now.
This is the conclusion. And I may just point out, Your Honor, that we did file our brief first, so technically we were the moving party. So that would entitle us to 2 arguments.
Yes and
But-
no, because it's actually, the genesis of this was a motion to strike.
Okay. Well, at any rate, I was concluding, Your Honor.
All right.
And maybe I shouldn't have taken so long, because this really is an extremely simple issue and should be resolved simply by looking at Detective Van Adder's testimony, and I do apologize for that. And I hope I haven't made it sound more complex than it really is by treating it perhaps with more seriousness than it actually deserves. But at any rate, in Dorsey, what happens was that a bank record was introduced in a non-sufficient funds case under the business records exception, but there was no testimony at all that it was prepared at or near the time of the act conditioner event, and no testimony as to the mode of preparation. And counsel in that case for the defense objected, objection no foundation, repeatedly, and the objections were overruled. What the court held in Dorsey is that that objection was not sufficiently specific, because when you're making an objection, you have to state the specific grounds, which would mean that the specific objection that should have been made at that time is objection, no foundation, as to manner and mode of preparation.